Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and keep their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-7042. Anthony D. Givens et al., appellants versus Muriel Bowser, in her official capacity as mayor, Washington, D.C. et al. Mr. Belling for the appellants, Mr. Bowe for the appellees.
Proceed, Your Honors. Good morning, Your Honors. My name is Eitan Bellin, and I'm the attorney for the appellants, Anthony Givens, Deborah Bowser, and Eugene P. Givens. Your Honors, first I'm going to deal with the mootness issue. The district court erred when it found that the appellants' PME claims were moot. As a result of the defendants' admitted violations of the PME rules, Ms. Givens, Eva Mae Givens, of whom the appellants are the successors, was forced to pay thousands of dollars to her nursing home care that the defendants later admitted she was not required to pay. Those monies have never been paid back to Ms. Givens or to her successors, and therefore there is still unremedied damages that she and the appellants have suffered. The fact that the defendants belatedly paid the nursing homes monies after the appellants had already paid them monies does not change that result. Again, the appellants still suffer the damages as a result of those PME violations. Now, moving on to the fair hearing timeliness claims, Your Honor. These claims satisfy the inherently transitory exception for mootness. First of all, no one contests that they satisfy the first prong for the mootness test, that the claims are inherently transitory and a district judge would not have time to rule on an issue of class certification before the case would become moot. Nobody contests that, and that's what the lower court found. It's really on the second part of the test, whether the class members retain a live claim at every stage of the litigation. Now, the first amended complaint and the proposed second amended complaint say that these violations happen repeatedly. The first amended complaint says more than 40 times. The proposed second amended complaint says it happened many, many more times. And under this court,
that complaint's not before us.
It is not before you, except for upon the consideration of whether the district
If we
judge.
ever get to that, then you
Okay.
about the second
All right.
complaint. But for now, it's not here.
Okay. Well,
What's the basis for the 40 number?
Your Honor, I will admit up front, it was an allegation. There was no way to.
What do you mean by allegation?
There was no way to prove or
How
disprove.
did you come up with 40?
It was a number we just alleged, Your Honor, upon information and belief.
What information?
Well, from our discussions with people, we believed that this had happened many times to Medicaid recipients or applicants in the District of Columbia. But no, there is no specific fact that the appellants learned that where they had actual numbers.
How many people were you discussing this with?
A number of practitioners,
A
Your Honor.
number of practitioners?
Yes.
You know, how many? And how many they said they knew about?
Your Honor, it was sort of a general discussion. There was no, in other words,
So there's nothing concrete at all about the 40?
there's nothing concrete at all about the 40. And the reason for that.
Some volume is necessary for your allegation that this is going to have enough volume that there'll always be a plaintiff who has a live claim.
I understand, Your Honor, but under this court's precedence, when the information is peculiarly within the possession of the defendants, which is the case here, you're allowed to allege it on information and belief.
You still can't just make up a number.
Well, in this sort of circumstance, Your Honor, I believe that because federal law prohibits disclosure of any Medicaid information about Medicaid people, this is a special case where we have a federal law and federal regulation.
You don't need the names. I assume there's like a DC FOIA law you could put in and say how many, tell us how many.
All right.
Records on how many were delayed.
I understand, Your Honor. Then I'll move on.
You could get more information.
Possibly. It's possible.
And when the proposed amended complaint went up to hundreds and hundreds, was that based on more discussion?
It was not based on more
You just
discussion.
decided to multiply it.
not as simple as that, but anyway,
What did happen? If it wasn't as simple as that, how did you go to hundreds and hundreds?
no, Your Honor, it's basically as simple as that. I'm sorry. But I'll move on from that. I'll move on from that, which is why we filed the proposed second amended complaint. In terms of the claim with the PME claims, we actually have statistics from the defendants themselves that show that they have not been able to render decisions in hearings, which include Medicaid fair hearings, within 120 days.
Yeah, what percent Medicaid fair hearings are of that group of hearings your statistic was about?
We could not tell you that, Your Honor. Well, the percentage was, in some of the years, it was up to 75% of the cases they didn't do with 120 days. I don't know what percentage of the Medicaid fair hearings were.
You had a group of hearings where they weren't doing hearings in 120 days. Within that big group, we don't know what percentage were Medicaid ones?
No, we don't. There was no information like that available, Your Honor. And I believe that it renders plausible, though. The question is whether the allegations render plausible the claim that they did not make fair hearing decisions within Medicaid fair hearing decisions within 90 days. And I would submit.
Let me make sure I understand what you just colloquy here. If it's 40 or whatever number, you don't know what percentage that is. You don't know the denominator. Is that correct?
Of specifically Medicaid fair hearings, no, Your Honor. But of OAH hearings, which include fair hearings, yes. And that satisfies the minimal, at least the minimal.
What percentage is that?
I'm sorry?
And what percentage is that?
Oh, some of them were up to 50, 40, 50%. In fact,
Yeah, I'm getting this. You're saying of a subset of certain type of hearings, the percentage for delayed is what?
it varied over the years. Could be as up to 70%, could be 50%. All the details are listed in the brief, Your Honor. We cited the very statistics from OAH. So what you basically have here.
50% of the time that happens, what basis is there for thinking it's a policy practice?
Well, Your Honor, I think that
slipping up.
I don't think 50% is slipping up. I think if you look at the case law, Your Honor, something like 50, 60, 70% is more than enough to say that there's a policy.
What if it's just that they're backlogged?
They're not allowed to be, Your Honor. The case law specifically says that they must follow the timeline.
Yeah, that's right.
So they can't be. 50% is not acceptable. 20% is not acceptable. They can't be in these.
Right, but just to say some percentage don't get heard on time and therefore it's a policy or practice that won't wash, right?
I think it will wash, Your Honor. And
Whatever the percentage.
Not whatever the percentage, but if you look at the percentages in these cases, they were trying to get to.
We don't know those percentages are talking about Medicaid hearings. It's
We do.
Some sub-percentage of that percentage.
I think it's a fair inference. Again, Your Honor, we do
How
not.
is it a fair inference if we don't have any sense of what the percentile of all these OAH hearings are attributable to Medicaid claims?
Because we don't have the burden of proof here, Your Honor. All we have to do is show that it's a plausible claim. And
I
it's
know, but I'm going to try again. To know it's plausible, we have to have some, plausible just doesn't mean I said something that isn't necessarily foreclosed by facts. What it means is there has to be some basis. And so if you were to look across the federal government and say, here's every ALJ hearing that they do, and X percentage of that, 60% of them are not on time. Therefore, it's plausible to believe that Nuclear Regulatory Commission ALJ decisions are not on time at a material percentage. You couldn't do that because there's just so many different subject matters covered. And so the same thing here, and maybe I don't know enough about the district, but I don't know how many different categories of OAH subject matters go into these OAH hearings. And without knowing that, which should be something you could find out, without knowing what percentage of those hearings, or even how many different subject matters they cover, then I don't know how we get to plausibility.
Your Honor, it doesn't have to be plausibility, as you know, it doesn't have to be more likely than not. It does not have
I'm sorry.
to be. Does not have to.
Saying more likely.
No, I know.
I'm saying plausible.
Your Honor, I understand your position. Our position is.
I don't have a position, I have a question.
Okay, so my answer is that I believe that it is plausible when you have these high percentages of failures among their hearings. It's reasonable to presume that the subset is also is also
Turned out
violative.
Medicaid hearings were 5% of that total. Would it still be plausible?
Sure. I mean, as the Supreme Court said in Rawlinson in 1977, where they made a determination saying that certain issues that were shown nationwide about people's health, they decided that that could be said about the people of Alabama as well. And the court felt that that was a reasonable thing. I think it was on summary judgment even, a reasonable inference there. And here we're not on summary judgment. And here we couldn't get the discovery. And I think that this does pass the plausibility test because given the terrible statistics that they have, it renders it plausible. Does it render more likely than not? No, not necessarily.
No one's saying you have to do that.
I understand, Your Honor.
So what theory of municipal liability are you pursuing? That wasn't clear to me.
The theory of municipal liability is that they had these reports, they've known about these things, and the heads of the agencies haven't done anything. In fact, in their own reports, they say we're trying to get to 50%. They haven't resolved this. Even their goals are below what would be permissible.
Their Medicaid offices?
I'm sorry, Your Honor?
Whose report?
It was the report of OAH, the Office of Administrative Hearings. And they said themselves year after year, we're trying to get to 50%. We're trying to get to 50% on time.
So I'm
And they
sorry,
couldn't do it.
so we've got sort of four theories of municipal liability. So there's adopted a policy. You're not alleging they've formally adopted a policy of delay. The decision was making by a policymaker. You're not alleging that.
No.
That there's actions are so consistent over time that supervising policymakers must have known.
That's the one, Your Honor.
Or should have known of a risk of violations of law, but showed deliberate indifference. You're in number three?
Number three, yes, Your Honor, because they themselves and
Where in your First Amendment complaint do you identify that it's that third theory of Monell liability?
I don't identify that legal theory, but
Our precedent says that's the end of the case. Says you have to identify.
well, as I understand it, the precedent says you have to allege facts that can be interpreted as a theory. But the Supreme Court has ruled that you don't have to have a particular legal theory. In one of the cases I cited from 2014, Your Honor, you have to have the facts that if accepted or is plausible would render this.
From, I think this is blue. If the plaintiff fails to identify the type of municipal policy at issue, court would be unable to determine, as required by Iqbal's second step, whether the plaintiff had provided plausible support for her claim. Although the court could try to surmise which theory of municipal liability has the strongest support in the complaint, this is not our role. It therefore follows that to state a valid claim against a municipality under Section 1983, a plaintiff must plead the elements of the relevant type of municipal law.
I think the issue is, Your Honor, and when it gets to the second, I see that my time has run out.
Did you do that?
Yeah, I did. We did it certainly, I believe,
Where
in the
in your
proposed second amended complaint, where we cite those statistics. The proposed second amended complaint, which we only get
The
to.
review now doesn't have that.
I would say that that's correct, Your Honor, but the proposed second amended complaint and the district court abused its discretion by not allowing us, may I continue? I see my time is up. The district court abused its discretion by not allowing us to file the motion to amend the second
Okay, but
complaint.
let's just talk about, first of all, whether it was proper to dismiss the first one as moot.
Even if, I don't, I'm sorry.
No.
I think given the inherently transitory exception to the mootness doctrine and the statistics that show that that OAH has consistently failed to render hearing decisions within 120 days, that's enough at this pre-discovery stage of the case to allege that there will be continuing to be violations, class members who are suffering violations of the fair hearing timeliness matters.
You don't dispute that Ms. Gibbons' individual claim for injunctive relief is moot?
No, that is moot at this time, Your
But you
Honor.
certainly
But a claim,
for damages.
yeah, and the damage claim is under the PME side of this, not the fair hearing side.
Right.
But
And then, so her injunctive claim is moot. And then, as I read your proposed First Amendment complaint, you want to substitute in her children as the class representatives?
we made a motion to substitute class representatives, which was granted.
And it was the children as the class representatives.
Well, we haven't made a class certification motion yet, but that's what we anticipate, Your Honor, that the
Okay.
children will be class representatives.
Have they ever been denied a hearing?
No, but they're the successors in interest, and under
I know, but you
DC,
just said her injunctive claim is moot, so I'm tryrying to figure out who could be a class representative for the injunctive claim.
well, successors to,
Successors to a moot claim do not have a claim.
if it satisfies one of the if it satisfies one of the exceptions to mootness, I believe they do, Your Honor.
Okay.
So we believe that it does satisfy the exception to mootness. I agree, it's a moot claim. A person doesn't have their own claim if it's moot. But these people are allowed to assert under DC law, which is what you look to see what sort of,
They've never had a claim. For
they
hearing.
they are allowed to adopt it as successors, as the case law says. In DC specifically allows successors to do Section 1983 claims. There's case law that says that. And
Case law
so,
that says successors who themselves have never experienced the injury for which injunctive relief is sought can nonetheless be class representatives on an I'm only talking about the hearing claim, the injunctive claim at this point, can be adequate class representatives, even though the claim to which they succeeded is moot and they have never experienced the injury.
well, we haven't made a class certification motion yet, Your Honor, so I think that would be a bit premature. What we're asking for is to be able to file a proposed second amended complaint. So I actually, I have not researched that, but I do believe that they can bring it, just like you can have a headless class, bring when there's no one who has any more injunctive claim. There are many situations where that happens. A person who succeeds the interest of another party hasn't suffered damages either. And they can also bring a claim. If the executor was not related to them.
Injunctive relief is maybe different, maybe not, maybe.
I'm not aware, I would just say, Your Honor, I'm not aware of any cases that make that distinction. And I don't really see a principled basis for making a distinction between an executor bringing a damage claim that they were never damaged for, qua individual, against an executor bringing an injunctive claim for which they never suffered any relief. I mean, under that theory, no executor could bring any claim unless they were somehow beneficiaries of the.
They're getting money into the estate, but they can't get an injunction.
Well, but an executor doesn't benefit from that money, Your Honor.
No, but it's their responsibility to get the money into the estate, legal responsibility. Anyhow, are there any more questions from my colleagues?
I have one question on the dismissal with prejudice or without prejudice. I think dismissals for lack of jurisdiction are generally without prejudice, but you, I think DC both seem to think that this was a dismissal with prejudice. Is that right? Well,
That's because besides the issue of mootness, the court also went on to decide that there was no pattern, that we hadn't sufficiently alleged a pattern. And so Judge Sullivan actually ruled on, even though I agree with Your Honor that he didn't have to once he found it moot, he went on to rule that as a substantive matter, the complaint didn't state a claim.
Is it possible that the claims that if some claims were correctly dismissed for mootness, then they should have been dismissed without prejudice. And then if some claims were not moot, but were correctly dismissed under 12b-6, the presumption would be they were dismissed with prejudice.
I agree, Your Honor. The court below did not dismiss it with prejudice when we made our motion for re-argument.
I guess if we find that some of the claims are moot, would it be useful to remand to the district court to ask if the district court intended to dismiss those claims with or without prejudice?
My client certainly would have no objection to that, Your Honor.
Do you think you've forfeited the argument that there's a general rule that mootness dismissals are generally without prejudice?
I don't think we forfeited it, Your Honor, because the judge, again, made substantive rulings. We had to assume it was with prejudice. If it were not, the mootness may have been without prejudice, but then the judge went on and made substantive rulings saying that as a substantive matter under 12b-6, it was moot, it was with prejudice. Now, whether if he had specifically said it was with prejudice vis-a-vis the mootness argument, that's another thing, but the judge never said that. But he did make a decision based on.
He said everything was moot.
He did.
In the alternatives.
Yeah, he did.
You're not supposed to do, if we don't have jurisdiction, you're not supposed to go on and talk about the merits.
I agree with you, Your Honor, but that's exactly what the judge did.
I understand.
And so we have to assume that the judge was making alternative claims and that he dismissed this with prejudice based on those claims. We thought he was wrong on the issue of this mootness, but then he went on to do the substantive decision. So it was a dismissal with prejudice on that. And so we believe that the court erred in doing so because there was a way that our client had a proposed second amended complaint that was put before the court. At the same time, they filed a motion for substitution. The magistrate judge granted the motion for substitution for the purposes of filing objections to the magistrate judge's order, but did not grant, but it held it in abeyance regarding our motion to amend. The district judge, we appealed, we objected to the district judge. District judge said, you lose, and when we went and made a motion for re-argument based on 59E saying there was a motion to amend, he said, you can't do that because you never appealed the holding in abeyance by the magistrate judge.
Yeah, I think we have all that.
Okay.
For the record. Thank you. We'll give you a couple minutes for rebuttal, though.
Thank you, Your Honor.
You're both? Both.
Both.
Thank you.
Morning, Your Honors. May it please the court. Russell Bogue for the District of Columbia. I'd like to start with what I take my friend to have conceded already this morning. The first is that there's really only two claims before this court. The first is the individual claim for damages for misgivings, the error in calculating your patient payability, and the second are the Class B fair hearing claims. Now, on those, I take them to have conceded that there's essentially no basis for the number 40 in their First Amendment complaint, which, as Your Honor noted, is the only complaint in front of this court. We also take them to have conceded that they have no theory for Monell liability. Now, we think both of those are fatal for independent reasons. The simplest way to resolve this case is the mootness issue. It is my friend's burden to prove that there's an exception to mootness. We take them to have conceded that without the inherently transitory exception, their claims are moot. So they need to assure you that this exception applies. And we think they haven't come close to meeting that burden. They have to show, as they've mentioned, that there's a constant class of persons that are suffering fair hearing delays. The only factual allegation is that 40 such persons have suffered delays over the past 3 years. Now, that is a drop in the bucket in terms of how many hearings these come before these judges. There was some discussion about statistics. This is not in the record, but there are several hundred Medicaid fair hearings every year. And in terms of timeliness, if Your Honors are concerned that there is some ongoing timeliness issue, again, this isn't in the record, but just to give you some background to this, the Office of Administrative Hearings for the District of Columbia goes in front of the Council for Performance Oversight every year, and they answer questions about how timely they are, what their statistics are for the year. And just for fiscal year 21, the average to get a hearing in front of Medicaid Appeals Board was 50 days, and the number of days to reach final case resolution was 87 days. Now, that's well within the 90-day regulations. Obviously, in this case, there was an unfortunate delay in Ms. Gibbons receiving a fair hearing, and obviously there was an
None of that is in our record, though.
It's not in your record. I recognize
Is it in
that.
a report?
Is it a public testimony?
It's a public. This can be, you can look this up and we're happy to provide briefing on this. I will say, we don't think this should turn on statistics. I mentioned this just to assure you in case you're worried that there's some ongoing delay that we're trying to dodge. That's not the case. The reason why
Can I
there's,
ask a little different question?
Sure.
No one's accusing you of dodging anything.
Sure.
But they had this statistic, they have a statistic about delays generally in Office of Administrative Hearings.
correct.
Is there publicly available information that one tells them what percentage of OAH hearings are Medicaid hearings? Is that something find outable? Sorry, I made that word up. Is that something that can be determined? And two, are there separate statistics anywhere as to timeliness just as to Medicaid hearings? Apart, you've just mentioned this testimony. Are these things that can be found by people or?
As to the first question, I'm not sure. It could probably be backed into by looking at what the other hearings are, the statistics for the other hearings. So in this report that I just mentioned, I apologize that it's not in the record. They go through statistics for various types of hearing, supplemental nutrition assistance hearings,
So
et
it's not
cetera.
all entirely within the control of the government, this information?
It's not all entirely in the control of the government. And we'll just point out that, these statistics aren't in their First Amendment complaint. So in our view, the only factual allegation you have here is that this happened 40 times over 3 years. So we think that's just not enough to carry their burden on that.
On the Ms. Gibbons damages claim, she says district made a mistake. District mishandled my case, violated the law in doing so. And I've suffered out-of-pocket damages. I'm out $20,000-ish, period. Why is that claim moot? I'm not talking about whether she'll be able to recover or anything on the merits. I'm just asking about why that claim would be moot. She/her estate are out of pocket $20,000.
She may have a pocketbook injury, Your Honor, but mootness is also determined by whether or not there's any relief that this court, whether or not she's been provided the relief that she properly sought. Our argument is that.
No. The relief she properly sought was recovery of out-of-pocket damages. It's a district that has tried to turn that into, oh, you wanted us to pay the facility where you were living and then paid the facility. But her claim is, if I read the complaint as, thank you very much, you fixed your problem going forward, but I had to pay that $20,000-ish out of my pocketbook, and I am still out that money. That is, pocketbook injury like that is traditional type of injury. It's a live injury. It has not yet been reimbursed. Someone else has the money, but she has not been redressed. That injury has not been redressed for her or for her estate. So I'm having trouble understanding how that claim is moot.
Sure. I'll get at this by trying to explain how we think this normally goes, and let me know if this is not responsive to your question. So our understanding of how these claims typically work is that money goes from, in this case, DHCF, the state agency, to the providers. That's how, when these errors are made and there's a claim that you haven't paid the provider enough, it goes from the district to the agency. And there are two reasons for that. The first is that that's how the Medicaid statute and implementing regulations say it's supposed to go, that payments go from the state to the provider. And the second is a practical reason, which is that providers bill the district, and we have existing relationships with providers. They're reimbursed at preferred rates. Okay.
I understand all that.
So
And eventually the district paid the nursing facility.
right.
How did that redress her out-of-pocket cost?
Because we construe her claim as you made an error in paying the nursing facility. So one way of her saying, I'm paying too much
If
is
she
you're
says
paying
my
too little.
error, my injury is, thank you for giving someone else the money, that does not redress my $20,000 out-of-pocket loss.
Well,
That's what she's alleging. If they say that's what she's alleging, that would not be moot.
well, we think what she's saying there is the nursing homes haven't paid me back yet. Now, we don't understand why that would be the
I don't know
case.
why you get to say what she's thinking.
Right.
If her complaint says, and you don't get to psychoanalyze it, or say, here's what we would like it to look like, here's traditional things, and normally that traditionally works because people don't die before they get the benefit of that money, credited against future stays. But if she says in her complaint, I'm out of pocket this money, and today I am still out of pocket this money, it's not moot. Your arguments about traditional payment forms and stuff may go to the merits, but I don't understand how it makes it moot. Or are you making a mootness argument or a standing redressability alone argument?
We're making a mootness argument. We understand that
How is that moot?
because our understanding of what makes it moot is that if the relief, we understand that she's saying we're responsible for that money. Our response is we're not responsible. So asking for us for that relief doesn't keep your claim live. We understand that she feels.
What, asking the district for relief from out-of-pocket costs doesn't keep a claim live? I think
If-
that's exactly how these things work.
Well, our understanding is how it works is you ask the district to correct the mistake that you allege, which is that we didn't pay the provider enough
correct-
money.
The mistake that she alleges was clearly, fix it going forward. And two, I'm out of pocket.
Right,
She's still out of pocket.
right. And our response to that is we believe that she's out of pocket because the nursing homes haven't upheld their end of the
Well, you-
bargain. Not that we have,
That may
so
be
we
your
never pay
belief,
her
and that
money.
may be a merits argument, but she says, wrong, I'm still out of, you did it to me, and I still haven't been redressed. You hurt me, district, not the nursing home, and you have not remedied my pocketbook injury. That is not, do you have a case that says that is a moot claim?
We would point to conservation force, Your Honor, where they said that when you received the relief you sought. Now, I
Okay,
understand.
and if that's not, so this all just turns on how we read the complaint. If we read the complaint as the relief she sought was fix my pocketbook injury, you would agree there's no mootness.
I think what we'd add to that is if that's not relief properly sought from the district, if that's not the type of relief that the district
That's the
provides in
only
these
thing you failure to
circumstances.
state a claim to me, that doesn't sound jurisdictional.
Sorry, say that.
If you say that's not something you can get under the law, that sounds like failure to state a claim, not mootness, which is jurisdictional.
Well, we read conservation force to say that if you've been provided the relief that you sought, and we understand that she's saying she's
That
seeking
case doesn't help
reimbursement.
you if that's not what she sought.
Right.
Okay.
Her original allegation was you made a mistake in calculating my PME deduction. And so our response is we've now fixed that and we've made back payments. It's not just going forward. We've made back payments, and that's standard operating procedure. And there's a reason for that, which is that we have pre-existing relationships with these providers. We do not provide reimbursement. In fact,
Okay. But if the complaint says award Ms. Givens monetary damages, then that's what she's asking for.
right. And I guess our response is we never provide those. And so we read that to be a moot claim because by shoehorning in her,
You never provide
Correct.
those, so you think it's not a
not,
viable claim at law.
we never provide reimbursement is what I'm saying. And so what
You
our,
may not under the Medicaid program, but I assume you have a judgment fund of some sort, at which point you can pay damages.
correct, that's right. Of course, we can always pay damages.
And so if she thinks awarding Ms. Givens, and she has the class in there too, but monetary damages, an amount to be determined at trial.
We-
That's what the complaint says.
Right, Your Honor, and we think that's a claim
Doesn't
against
say
the
pay my
nursing.
nursing home.
I understand that,
Okay.
Your Honor. Yeah.
Do you have a view? Oh, sorry, you guys go ahead.
I was gonna ask
Just
The-
prejudice.
for the prejudice,
Go ahead.
but you want to ask?
Nope, I was going to that. You go to that.
If we hold that some of the claims were properly dismissed for mootness, do you think that we should read the district court to have dismissed them without prejudice?
You know, this argument wasn't pressed by appellants, so if you believe that some claims were dismissed for mootness and you'd like to remand to the district court to clarify that dismissal, that's fine by us. Obviously, if they're moot, they'd have to find another person.
That may be the best approach for that. A more aggressive approach would be, we just say as a general matter, since claims for lack of jurisdiction are generally dismissed without prejudice, that we read the district court to have dismissed the moot claims without prejudice. Would you object to that?
No, we wouldn't. There are no further questions.
Thank you very much.
We'd ask that you affirm. Thank you.
Mr. Bellin, we'll give you 2 minutes.
Thank you. I just wanted to address the last question asked by Judge Walker. I think it's clear that the district court improperly dismissed on mootness with prejudice because it did not allow us.
I think he just gave you what you want.
Okay, so then you know what? Then I will stand on my briefs and I have nothing else to add, Your
Let
Honor.
me ask a question
Sure.
along the lines of what Judge Millett and your opposing counsel were discussing on the complaint. Does the complaint allege that your client paid the nursing home?
Yes, it does.
I think that's probably the best inference of what it says, because it says she was required to pay it. And if she hadn't been required to pay it, she would have been able to pay off a pre-existing debt. It does, I'm not sure it expressly says that she did pay it. Did she pay it?
She did pay, Your Honor. And I think if you read it, the complaint in the light most favorable to my client, that's what
I
it
think that's
says.
probably.
Unreasonable inferences.
There are no other questions?
No, I have a couple more questions.
Oh, you do? Okay, please.
So, do you agree that the Givens children were only parties for the limited purposes of objecting to the R&R?
I understand that the magistrate judge granted the motion for substitution only for the purposes of the objections to the R&R, but he reserved, he said he was going to only rule on the rest of the motion for substitution if and when the district judge made his determination on the case. So we moved to be included for all purposes. It was the magistrate judge who decided on his own to make it for limited purposes, which we say, by the way, even though we didn't agree with it, it certainly was within his discretion to do so. But what wasn't within the discretion of the district judge to say, oh, you didn't appeal that holding in abeyance, and therefore I'm going to dismiss the entire complaint with prejudice and not hear your motion to amend. That was where the violation was. It was perfectly for the district judge to say, well, I'm dismissing it with prejudice because you didn't file an objection to the massively discretionary decision of the magistrate judge to not decide part of a motion, and to say that we should have filed a frivolous objection, which under the case law it would have been, is certainly not a sufficient basis to say that a case should be dismissed with prejudice. We think that that's an abuse of discretion, Your Honor.
Thank you.
Thank you very much.
Thank you very much, Your Honor.
The case is submitted.
Case number 23-7061, Andrew Hansen et al. Appellants versus District of Columbia and Pamela A. Smith. Mr. Wagner for the appellants, Mr. Patak for the appellees.
One.
Good morning, Your Honors, and may it please the court. My name is Edward Wanger, and I represent the plaintiff's appellants in this matter. With the court's permission, I'd like to reserve 4 minutes for rebuttal. The case before this court begins and ends with Heller, as clarified and resuscitated by Bruin. In Heller, when the Supreme Court struck the district's categorical ban on operable pistols, it held that the handgun ban amounts to a prohibition of an entire class of arms that is overwhelmingly chosen by the American society for that lawful purpose. Whatever the reason, they are the most popular weapon. A complete prohibition of their use is invalid under the Second Amendment. This case before the court involves an arm, standard magazines that hold more than 10 rounds, that this court 10 years ago in Heller 2 observed were common. In fact, every circuit court to address this issue has concluded that plus 10 magazines are common under any conceivable definition of that word.
Are we bound by that determination in Heller too?
No, Your Honor, but I don't believe on this particular
Why wouldn't
issue.
we be bound by that? The
Well,
company-
if the court decides that the
No, I'm not asking you to say what I want to hear. I'm asking
No,
you
I
to
would-
tell me what
I would
the
certainly,
law
I would
is.
have no objection if
I'm
we,
not asking if you have an objection. I'm asking you analytically,
Mhm.
while there's Supreme Court certainly changed the intermediate scrutiny aspect of that decision, common use is an issue that remains under Bruin. And we found there on the record that there was common use of large capacity weapons, larger capacity magazines. So does that, I'm just asking you to tell me whether
under the law,
that's still binding.
under the law of the circuit, Your Honor, I would say that is binding on this court.
So we don't have to wrestle with what on earth common use means, which many other courts have been dealing with.
That's correct, Your Honor. There's no reason to revisit that, and under that
That
really,
also answer the question of whether it's an arm.
absolutely does, Your Honor. I think so. And to the
I
extent
think
that,
so. We didn't break that question out. So I'm trying to figure out whether it's some kind of inherent in common use, but I could be wrong.
I don't think it's inherent in common use, Your Honor, but I think,
Common use is what?
well, common,
Common use for self-defense.
Mhm.
There's no reason defined as common use if you don't think it's an arm.
that's exactly right, Your Honor. I think analytically, and I think
So
just
those type of-
implication,
those aspects of Heller 2 are still binding on this.
absolutely,
Those
Your
sort
Honor.
of Analytical questions about usage and
Mhm.
those are binding. It's just
Correct.
intermediate scrutiny stuff that we.
That is correct, Your Honor. The only thing that was cut off under Heller 2 was the idea that you can means and scrutiny your way out of a fundamental right. So as I was saying, and as Judge Millett has recognized, these magazines are astoundingly common.
I just said a question. I don't say whether I recognize it or not.
No problem, Your Honor. The test is this, though. If something is a bearable arm, which it is, it's presumptively protected by the Second Amendment from any flat prohibition. The only way that the government can overcome that presumption is by showing that the arm is both unusual and dangerous.
Can I ask another thing? It sounds like you have both, as I read your, like, you have both a facial and as applied challenge. Is that correct? Or are we really here focused for the PI, is it PI for the PI purposes, are we just focused on the as applied challenge?
No, Your Honor. I think that the court is well within its rights to reach and say that as a facial matter.
Did you argue to the district court that you wanted a preliminary injunction based on the facial and as applied challenge?
Did, Your Honor.
Focus on the as.
I think that the focus was primarily on the as applied, but we didn't forfeit or waive the argument that this law is facially unconstitutional under the Second Amendment.
But my understanding also is that you agree that there's some level of magazine that could be prohibited as not in common use or not in common use for self-defense.
If that magazine is not in common use for lawful purpose,
For
then
example, so you're more an expert, far more expert than me in this. So what would that be? Would that be I mean, I know your clients range from sort of, I don't know, 6 or 8 to 18.
I think the problem.
And you said, I think you say that's sort of within the standard issue range. Would 30
30-round magazines are common for rifles, Your Honor. I'd say that
but
for handguns, for the best-selling
handguns is sort of
that is the focus of this. But we
pretty
want to make
established territory. so
absolutely,
far.
yeah. But we want to make sure that we also recognize that 30-round magazines are in common use for rifles.
We don't have anything in that record before us.
No. But the best.
Okay, so we don't have
Yeah.
anything on that for the PI.
Okay, so for the purposes of the handguns, though,
Mhm.
some of the best-selling handguns, we referenced these in our briefs and put this before the district court, is that of the top 5 selling self-defense pistols, the Sig Sauer P320, the second best-selling pistol, that'll come standard anywhere from a 17 to a 23-round magazine. So if you're looking at that range, the focus really is, and the test is, are these commonly chosen by the American people
I'm
for
trying to figure out,
self-defense
so there's-
purposes?
For a facial challenge, you have to show that there's no application of this law that could be constitutional.
Right.
But if there is, and we're doing this through a preliminary injunction lens, so it's
Mhm.
even, more of a burden on you than it may be at the merit stage. And that is, if you haven't argued here and you haven't created a record for PI purposes, not talking about what you could do on when you get to the merits, if you haven't shown that 25 or higher is common use for self-defense and meets all the other criteria for protection under the Second Amendment, then your facial claim fails. Your as-applied one
Mhm. That's correct, Your Honor. Under
goes
that,
only
yeah,
up to 18 for your clients.
correct, Your Honor.
So facial's off the table for PI purposes.
Just for PI.
The likelihood of success. So we really are talking about an as-applied challenge. That's what this record has been for this preliminary injunction.
Absolutely, Your Honor, and we
That
acknowledge
range is
that.
kind of 6 to 8. I think the highest I saw for your clients was 17, but I think you mentioned things come out with 18. If we say 6 to
Right.
18 is the range for common use, and you say for self-defense, at least common for standard issue is, let's say, 6 to 18. Is that correct?
I'm not sure if I caught that question. You said
Sorry.
6 to 8?
18.
6 to
Not
18.
eight.
Yes, okay, just want to make sure, yes, because that would be a different
For
story.
your as-applied challenge, what your clients have here. The highest I have them in the record is 17, but we could say 18, because I thought you put evidence in about some standard issues at 18.
If the inquiry is limited only to these clients, the record suggests that they
Let's
want
do an
to,
as-applied challenge.
correct, for the as-applied challenge, their only focus, the highest that any of my clients possess, they want to carry in the district is 18. I want to
Okay,
make
I
very
thought it was
clear
17,
though.
But you're telling me 18. Okay.
Well, yeah, 17. Well, I want to make
17 or
very clear.
18?
You're talking about
17 is in the record, Your Honor.
17 in the magazine or 18 including the one in the,
17 in the magazine plus 1 additional in the chamber.
Right.
To
We
be
don't-
very-
We don't
yeah.
dispute that one you can have in the chamber either way. So
Right.
then we're dealing with 11 to
So
18.
17, I think, is, for purposes of these clients, 17 is the number. For purposes of the Second Amendment inquiry, common use is the watchword. And we would submit the common use goes, roughly speaking, to about 23 based on the record before the court. If this were a case about 50-round magazines,
But again, I thought we
Yeah.
got to the point where for the PI purposes here, we're looking at.
I'm agreeing. No, I'm agreeing.
Oh,
I'm saying
yeah.
yes.
no, for
I-
PI purposes,
fine,
for
we're-
PI purposes, yes, I agree with Your Honor.
but in your colloquy in the district court, if I recall, you said 20. You would have a hard time defending more than 20 for a handgun or 30 for a rifle. Isn't that correct?
I believe it is, Your Honor. Like I said, whenever we actually looked in the record and we put into the statistics that are based on the sale of
I'm
pistols.
asking about the record of this.
That is correct, Your
colloquy.
Honor. Yes, the colloquy at the district court was focused on anything above 20 for pistols. for pistols would likely be
Right.
harder to
Right,
justify.
so I think anything more than that is, you've given away.
I'm not willing to suggest, Your Honor, that we've waived that. I think that that was perhaps one of the arguments. We would like to clarify that a little bit if it were to go back down to, for any additional evidence.
You're just talking about for this PI stage.
Mhm, yeah. So for the PI stage, like I said, our clients have handguns with magazines up to 17, and it was argued that anything over 20 would likely be a little bit harder
But
to
as
argue.
applied, it's going to stop at
Correct.
17.
Correct.
So, okay.
Mhm.
All righty.
So back to what I was saying, the test is this though. The only way that the government can overcome the presumption is by showing that the arm is both unusual and dangerous. And Bruin makes crystal clear that it's the government's burden at this step. The district court got it right, and I believe that this court will also, when it found that magazines are bearable arms under Bruin's definition, they plainly facilitate self-defense. On this record, there are no fewer than 100 million, perhaps as high as 500 million higher capacity magazines that are in circulation in America today.
Is that the,
It's the English Declaration.
no, sorry,
That's-
what
yeah.
I'm asking is, are you talking about ones in sort of the 6 to 17 range?
No. These are the magazines that exceed
Okay.
the
And
district's
when we say
ban.
in circulate, what does it mean in circulation? Does that include purchases by the military and law enforcement?
No, these are civilian purchases, Your Honor.
Okay, are these law-abiding civilian purchases or non-law-abiding civilian purchases?
With the caveat that it's the district's burden to prove that these are
So
not
you're
being
you
used.
want a preliminary injunction here.
That's true, Your Honor.
That changes the status quo and will inflict irreparable harm on the district. I know you have your irreparable harm, I'm not overlooking that, but when you want to change the status quo preliminary injunction, and as applied, and it will cause irreparable harm to the government and the public interest, you got some work to do.
Mhm.
And so when you throw out statistics for your as-applied challenge, it would help to have some more particularity, because if that number you just threw out includes ones over 17 or even over 20, if it includes rifle magazines, which aren't before us for the PI, there's no record here that I've seen or arguments about that. If it includes criminal and non-criminal, law-abiding and, that's not the right way to say it, law-abiding and criminal or law-abiding
Right.
and not law-abiding, then I'm not sure how that's what I'm supposed to do with that.
So to clarify, those are pistol magazines that exceed the district's cap.
Mhm.
I would
So
look,
those are
yeah.
all 10 plus.
Correct. So I would look at it this way, even taking the bottom of that range, 100 million, there are at the peak, and this is, cited by the Brady brief, maybe 600, 700 mass shootings per year. Even if every single one of those are considered unlawful purposes, you're still talking about a
There's lots
fraction
of other
a fraction.
unlawful, those are horrific.
They are. And
Horrific, but there's plenty of, I mean, that's, I assume the flip side of your self-defense rationale is that there are people who seek to do harm to other people. And if all they had were bows and arrows, we wouldn't need this, right? So they have guns. I don't mean to put words in your mouth. That was my understanding of what the self-defense rationale is especially in your reply brief when you were talking about.
so to correct, I mean, I want to make
I
sure
don't have any idea
that
whether that statistic includes purchases or straw purchases for criminals, do we?
no, they're legitimate purchases, and that's
Legitimate.
established.
It's
They're
a no-
legitimate, sold to people who are allowed to purchase these. They can go and they can purchase these.
You
So
don't, I mean, that's what a straw purchase is too.
really, Your Honor, even if you include so let me be very clear. The rationale that the district, not only in this case, but even the district's Committee on Public Safety gave for advancing this categorical ban was that they wanted to make sure that you could prevent people from shooting rapidly and hurting a lot of people without having to pause to reload. That's the reason why I gave the mass shooting statistic. Even if we look at all shootings, 115,000 is roughly the average over the course of 1 year in America. Even if every single one of those shootings included one of these higher capacity magazines, they certainly do not, that would still be roughly 2/100ths of the number in circulation that are being used for demonstrably illicit purposes. There's nothing more that we need to show that these are overwhelmingly commonly used
Sorry.
and overwhelmingly commonly
Did you say
used.
demonstrably illicit or illicit?
They are demonstrably used for illicit purposes.
Oh,
They are demonstrably used for demonstrably. No. They are plainly, commonly possessed and overwhelmingly possessed by law-abiding citizens for lawful purposes.
And relevant lawful purpose is self-defense.
It's the way that Heller phrased it was lawful purposes like self-defense. That would certainly include self-defense training,
Well, the
which
district court in this case said self-defense was the operative one, at least again, for purposes of the preliminary injunction stage.
correct.
Everything's
Yeah.
open on the merits. So
Heller is
we're
not
focused here on self-defense for the PI.
That is correct. And even in those circumstances, even if we limit the lawful purpose to self-defense, we still win on this record because I believe 64% of the people who purchase these and want to carry these have said that they want to use those for self-defense. And it makes sense given the notion that, as the district has pointed out, there is an uptick in crime. There are problems out there. These are law-abiding American citizens who want to make sure that they can effectively meet force on force if the unthinkable occurs. So that's getting towards the,
Can I ask,
absolutely.
this goes to the balancing of the four factors. Why did you agree to a stay?
We agreed to a stay at the district court because we felt that the legal issues in this case were probably clear enough that if we brought this up on this record, the decision as a matter of law about whether or not these are covered, protected, and categorical bans are off the limit would be clear enough for the court so that it would go back down. And that's the reason why we asked for entry.
A lot of confidence in us.
Well, we felt confident in our position, Your Honor. And for that reason, that's the reason why we've asked not only for entry of a preliminary
I
injunction,
think
but also
the distinction between the facial challenge and the as-applied challenge cuts in favor of not accepting your invitation to grant a permanent injunction, period, full stop in the case here.
if the court is inclined to say that we want to limit this on this record to these plaintiffs before, we would certainly ask for a remand. We would ask for, in the finding of likelihood of success in the merits, that as a matter of law, the Second Amendment does not allow this sort of categorical ban. If additional evidence needs to be taken to satisfy this court that the record supports that this is unconstitutional as a facial challenge, we would certainly welcome the opportunity to argue that on remand.
Let me take you back to Heller 2 for a moment. Seems to me that we didn't answer the common use question, but reserved.
I believe that the way that it was phrased was that it was a recognition that these larger capacity magazines were common. I think the actual precise question that was reserved, it was assumed that they were used for common lawful purposes.
Cannot be certain whether these weapons are commonly used or are useful specifically for self-defense or hunting, and therefore whether the prohibitions, etc.
Correct. So it was assumed but not decided.
But we need not resolve that question, however.
Mhm.
So we didn't.
That's true, Your Honor, but on this record also, I believe that the record is relatively indisputable. The district, I don't think, disputes that as a matter of just pure numbers, these arms are astoundingly
I
common.
take the distinction, but
Correct.
insofar as you were insisting that Heller 2 resolve the matter, I think that's erroneous.
I think that the argument was that Heller 2 recognized that these were common. They reserved the question fully of whether or not they were commonly used for lawful purposes. That was how I read it. Obviously, Your Honor wrote the opinion, so.
But that is the key question.
Correct,
Even,
yes.
I mean, even if they're commonly used without commonly used for lawful purposes, it doesn't get you where you need to go.
That's correct, Your Honor. And that goes back to our argument that with the numbers of these in circulation, and even taking as a given the highest number of laws that could be broken, shootings that could occur with these are still overwhelmingly not used for crime. These are overwhelmingly used for lawful purposes. And of those lawful purposes, overwhelmingly used for self-defense.
When they are used for crimes, though, they are unusually lethal.
I would dispute that, Your Honor. Certainly, the concern about mass shootings and the focus on being able to shoot rapidly without reloading, to the extent that we're here and only talking about plus 10 pistol magazines, to Judge Millett's point that we're on the as applied level here, the ability to shoot that fast with a pistol is what I would suggest somewhat distinct from what I believe is happening with regard to mass shootings with the long guns and long rifles. That said, though, The fact that Heller considered that 70% of mass shootings were committed with pistols and still nonetheless found that that was not a good reason, that could not overcome the Second Amendment protection for pistols in that case, suggests that that sort of cost-benefit analysis, that sort of weighing the pluses and minuses, is something that legislators should not do and the court should not engage in. And Bruin really sort of reinvigorated that. They said that we've done, means and balancing from Heller to Bruin. And during that period of time, they realized that, means and balancing wasn't in accord with the history and tradition test that was set out. So those types of concerns, the back and forth about whether or not these are too dangerous versus whether or not common citizens should possess them, is something that Bruin took off the table.
Well, unless it can be fitted into historical.
Correct, but common use means that there is no historical tradition. If there was a historical tradition of a categorical ban on these arms, they would have never come into common use for lawful purposes. That's how the common use test fits into the historical and tradition Bruin test.
Just a couple more questions. First, just a fact one. How long have your clients been residents of DC?
Years, Your Honor. I don't have the precise number before me, but they've been here for a while.
When you say years, does that mean 3, 5, 10?
I can confirm that whenever I sit back down before rebuttal. I don't have that information directly before me.
Well, I'm sorry. How long his clients have been? The as-applied clients here have been residents of DC.
I'll get that information for you if it's out on
Thank you.
remand.
And then one thing I'm curious about is justices have said many times that banning automatic weapons would be consistent with history and tradition. Given that those did not come on the scene in any significant number, any materially significant number until the 20th century, what tradition of regulation are they talking about?
In that particular instance, Your Honor, I think that actually is an example of the government getting regulation correct. As a historical matter.
When did that regulation by government start?
So I believe if you actually look at, it was in the 1930s. And the reason why I want to make sure that.
1930s don't count.
Pardon me?
I thought your brief said 1930s don't count.
They don't. And for purposes of this, I want to make sure that the court gets the timeline correct, because even granting that they're looking at this from the early 20th century perspective, either way, the history and tradition, the citations need to somehow key back into the initial understanding of the American founding. The reason why Tommy guns, or machine guns in particular, are different is that they hit the civilian market in 1921. Those guns, and this is actually recognized by now Justice Kavanaugh's dissent in Heller too, those guns were a commercial failure. They did not sell. They were overly and prohibitively expensive. The people who bought those were the criminals, were the mafiosos, and they were using them for perhaps, as an example, one of the most infamous mass shootings that the world had seen, the St. Valentine's Day Massacre. That happened in 1929. The bans that some states experimented with, which to be certain were very, very few and far between. There were 4 bans. And the federal government deciding not to ban, but to regulate the sale of automatic weapons happened in 1934. So that was rapidly changing technology.
They can't be banned, they can only be regulated.
That's our position.
Mm-hmm.
That's
not what.
So let me.
So I'm still trying to answer my question.
Mm-hmm.
I understand the timing and the history, but then the language that has been used by justices has been they fit within tradition. And under Bruin, tradition means that I go back to find something at the founding that has a sort of same how and why. Mm-hmm. So what is that tradition for automatic weapons?
For automatic weapons, I think that the only wiggle room for the government to categorically ban those would have to be really stretching the dramatic technological change.
What were the justices referring to?
For purposes of automatic weapons, it's not clear.
M16s and Heller, so maybe they're wrong? That it wouldn't be consistent with history and tradition to ban automatic weapons?
No, not at all, because there is some wiggle room for dramatic technological changes in the precise when they speak of, and when Heller spoke about M16, they underscored that those were, and I quote, highly unusual in society at large. So to be able to actually key that back in, I haven't litigated myself an automatic weapons case. I don't know
I'm just trying to
exactly.
figure out how
Yeah.
this, after Bruin, you can have a type of weapon that technologically wasn't even a twinkle in any gun owner's eye at the time of the founding or even Civil War. The technology just wasn't there, and that technology doesn't materialize until 21st century. And so, but everyone, other justices, I think, Heller was majority opinion, feel pretty
Correct.
confident
Mm-hmm.
that prohibitions, of course, even for regulations, you're going to have to make the same type of showing
Right.
under Bruin, all fit with this history and tradition. And so we have arguments here and arguments on both sides, to be clear, but arguments on at least one side that these sort of the semi-automatic weapons, the rapid fire high capacity they have is a much more modern innovation. But yet they have to try to find, this is your argument, they have to try to find something back in time that parallels that. And so what I'm asking you is, are you aware of any back in time parallel that's relevant for automatic firearms?
I am not standing here, Your Honor. And I think that really emphasizes also that even the categorical bans on automatic fire weapons are astoundingly, exceedingly rare. At this moment, to this day, if
I'm
you're
just
allowed,
asking what the justices were, what history and tradition they were relying on.
that part of it, I don't have the answer to, Your Honor. But what I can say is, as a historical matter, automatic weapons are not categorically banned. You can get them. You have to jump through a lot of hoops. They might be prohibitively expensive. The average citizen, the average law-abiding citizen can still get those. For purposes of this case, though, the one thing that we know for sure is that if something has come into common use for lawful purposes, that satisfies the Second Amendment inquiry. Because if there's not a historical tradition of banning these semi-automatic higher capacity magazines, that means that there is no history and tradition of making them unlawful.
Ban, but in fact, as we've discussed, for purposes of our as-applied challenge, there's a range of these magazines from, shall we say, 6 to, maybe it even goes less than 6, but is 2? Is there a 2 or a 4? I don't know.
Not that I'm aware of for
Okay,
self-amendment.
so like 6 to 17 is what we're thinking about for this preliminary injunction. There's a range.
Correct.
They have not banned those. They have simply drawn a line that said, they had to draw a line and sort of said, we think over this amount is historically allowed for us to regulate, is not common use for self-defense, fits with our traditions and fits with the text of the Second Amendment. That's their argument. That if we have to draw the line somewhere. Now you agree that they get to draw a line somewhere.
They do, and that line has to
Okay.
be drawn commonly used for self-defense. They cannot carve out arms that are commonly
I
used for
understand, but
self-defense.
I'm just going here, is this a ban or this is what legislatures do all the time, and that is do line drawing? You're not banned on high capacity magazines.
In the district, you certainly
banned-
are.
No, you're not banned. You can't have ones that are more than 10. But 10 and one in the chamber, 11, that's a lot. And so the question is, it sounds like your argument is simply they did a line drawing, not a ban. They did a line drawing, but you think the line should have been at 17 for purposes of the PI. You can do more on remand for purposes of the PI.
Correct.
It should, you're likely to succeed for this status quo changing, irreparably harm inflicting preliminary injunction, because they should have drawn the line at 17 and not 11. I mean, you can have 10, so 11. So that's what this is about, is legislative line drawing.
It is, but that legislative line drawing is still a categorical prohibition on anything that falls above the line that's drawn.
Mhm.
And if that is a categorical prohibition, that line cannot be drawn consistent with the Second
It's not the
Amendment.
same as a ban on handguns
Oh,
or intense regulation of handguns. It's not the same as a ban on semi-automatic weapons. It is, we need to allow these under the Second Amendment. And the question is, how much lethality we're required to allow by the Second Amendment.
the reason why common use really has to be the watchword is Heller itself, Justice Scalia's opinion, considered these types of arguments. Why do you need a pistol whenever experts say a rifle might be better for home defense? And
Pistols
what
and
Heller
rifles are
said.
categorically different in very, very many different ways. Here, we're just talking
But-
about number of bullets.
But I
And
reiterate,
you agree that there's a number of bullets that they can ban.
Well,
You
certainly,
agree then?
those that are not in common use for lawful purposes, and that is their burden to show where that line lies.
Self-defense today, this morning, for purposes of the PI.
Correct.
Okay.
But I want
So
to,
if it's as simple as that, what role in Bruin does the passage about dramatic technological change, or perhaps more important, unprecedented societal concerns, what role does that play in the analysis?
I think part of the role in that analysis is keyed into the idea that Heller itself dealt with a categorical ban on a class of arms. The issue in Bruin was where could you carry certain arms? So they had to go through things. For example, the issue in that case was inside versus outside. An example of a dramatic technological advancement would be, okay, do we allow, does the Second Amendment protect people to carry firearms through TSA security? Certainly you have similar concerns. There might be an analogous history and tradition of banning arms, and they recognize it in sensitive places. Taking Bruin under the four corners of the issue in that case really sort of informs why it was that the court was so focused on dramatic technological changes, perhaps airplanes, and societal concerns, 9/11. So in those circumstances, the historical analysis becomes a little more acute. Heller, though, said that as soon as you have common use for purposes of today, self-defense,
Well, Bruin comes after Heller.
correct, it does. But Bruin really clarifies Heller.
That purports to clarify it. I'm not sure whether it helps
Yeah.
me.
But the clarification there, and I think it really is this, is that when you're talking about categorical bans on arms are indisputably used for self-defense. The government cannot satisfy based on the history and tradition test articulated in Bruin.
Suppose that unprecedented social concern, societal concern arises after something is in common use.
Under that circumstance, Your Honor, the Second Amendment is interpreted in Bruin suggests that is still protected under the Second Amendment.
So there's the arising of some unprecedented societal concern just has to go unredressed or ignored if it involves something in common.
Not at all, Your Honor, because the legislature has other tools. They have tools short of a categorical ban. I'm not going to prejudge.
But why wouldn't your argument apply just as much to regulation? If they couldn't find the analog, you've got common use, unregulated, at the time they act. They can't find some 1792 law that regulated this thing that did not exist remotely, comparably. How are they going to do it?
Well, for instance, in this case, if you're talking
Folks are
about,
going to challenge the regulations too.
pardon me, Your Honor?
Folks are going to challenge the regulations too.
They are, Your Honor, but I think that if I were up here and if, for example, the district had said that the only people who can possess plus 10 magazines are folks who have a concealed carry license, and they've gone through the training and demonstrated, be a very different case. We would have a much harder challenge to try to say
You'd
that.
still say it fails the Bruin test.
Not necessarily, Your Honor. I'm not prepared to say that. I don't think that it would
How would it
because concealed carry licenses, that's something that Bruin actually recognized are longstanding. Bruin didn't throw out, for instance, the concealed carry license scheme. It actually said that for as long as it's a shall issue scheme, we're not disturbing those findings. They didn't prejudge that at all. That would be an extraordinarily harder case.
So Bruin would allow the district to say only those who have concealed carry licenses through, let's just assume you're not challenging the regulatory scheme.
Correct.
For that, of a 6 magazine, that'd be perfectly fine.
Could you repeat that, Your Honor?
But the magazine would only be 6, not more than 10, not 10.
I'm not sure if I completely follow your question.
So I'm following up on yours. So you
Right.
say, if you had a case where they said concealed carry, high magazines, 10 plus magazines are banned except for individuals who have concealed carry permits, have been through all our safety requirements, background checks, law-abiding individuals. They're all banned, but as for those individuals, they may carry magazines up to 6.
Up to 6 or 16, Your Honor.
6.
So individuals who have, that would still
Your best golden individuals.
can only carry 6-round magazines? No, Your Honor, that would not survive Second Amendment scrutiny because you're still categorically banning a wide swath of people from possessing commonly held arms for lawful purposes. That would absolutely, under our theory, fail the Second Amendment's test.
Thank you. Thank you very much. Give you some time
Thank
for
you.
rebuttal.
Thank you, ma'am.
May it please the court, Ashwin Pathak for the District of Columbia and Chief Pamela Smith. And let me start with some of the colloquies that Judge Ginsburg and Judge Millett had with my colleague about Heller 2, because I do think Heller 2 is quite important in this case. And I agree with you, Judge Ginsburg. I think what the court did in Heller 2 is that there were basically two paragraphs that talked about common use. The first paragraph in Heller 2 talked about whether or not they were simply numerous in society. And everybody agreed in that case that, of course, large capacity magazines are numerous in society. There are millions of them out there. And then the court went to the second paragraph and it said basically that there wasn't enough evidence in the record to determine whether or not large capacity magazines are in common use or used specifically for self-defense. And it said that it would have to remand for that question to be more fully fleshed out with evidence. But then, of course, the court went on to apply means and scrutiny, an analysis that has been repudiated by Bruin. And so I think it's very indicative that the court did that, and it's highly persuasive for this case that even Justice Kavanaugh in dissent, in the footnote at the end of his opinion, he too said that he would have remanded on this question. Everybody acknowledged in that case that there were millions of large capacity magazines in circulation, but even he would have remanded this case to figure out whether or not they were actually in common use.
Seems like sort of a dim view of the American public, right? This could be so popular, so common. Could be the standard magazine that comes with the quintessential self-defense gun, to quote the Supreme Court. And yet, even though it's standard for the standard gun, it might be only in common use for unlawful purposes?
Well, I certainly wouldn't suggest that it's only in common use for unlawful purposes. But what I would say is that
it in common use for lawful purposes?
Well, I think it's in common use for all manner of reasons. Folks might like to collect them. They might like to have them. They might like to shoot them.
It seems like it has to be in common use for lawful purposes when it's the standard magazine for the standard gun. Unless you think the standard American is out for unlawful things.
I don't agree with that, Judge Walker, because I think it proves too much. I think there's 700,000 machine guns out there. Folks have them as collectibles. They have them because they like to shoot them. They may even have them because they subjectively think.
I think a lot of them are owned by police departments and government, right?
And many are owned by collectors and individual
about,
citizens.
You know,
And
how many are owned by?
I don't think we have that specific number in the record, but I will just say
500 million high capacity magazines. It's a lot of magazines.
I understand that, Judge Walker, but I think it can't just be a numerosity analysis. If the court in Heller and Bruin had thought that numerosity was the beginning and end of this test, those decisions would have been very short because they're the same number of handguns out in circulation. But instead, the court went through in Bruin a two-part analysis, step 1 and step 2 of Bruin, which started with a threshold inquiry that in our view applied the common use for self-defense test that is fully consistent with what this court believed was the test in Heller 2. And I'd point the court to 2134 of the Supreme Court Reporter, that's section 3A of that opinion, applying the test that it had previously set out to carrying handguns, where the court said in that very first paragraph that everybody agreed in that case that handguns were commonly used today for self-defense. That's the language the court used there. And we think it has to be something more than numerosity, because if it's pure numerosity, that results in a circularity that is simply untenable. I don't understand how it could be the case that there are 700,000 machine guns in circulation. That's more than the 200,000 stun guns that Justice Alito mentioned in Caetano.
You don't know how many machine guns are in private hands.
It's certainly, they have not disputed that it's hundreds of thousands. Nobody has disputed that.
Take a step back and tell me, I'm going to walk through what I think is the test, and then you tell me where I'm going off the rails. So I think you start by asking, is it an arm? Is it an arm in common use? Maybe even you can extend that to, is it an arm in common use for lawful purposes? Maybe even is it an arm in common use for self-defense?
Correct.
And I know you think you win already, but let's then say, I think the answer to those things are yes. Then I think there's a history and tradition inquiry that says, is there a history and tradition of this regulation? And for example, one history and tradition, I think the Supreme Court may tell us in a few months, is for unusually irresponsible people, there is a history of keeping guns out of their hands. I think the history and tradition that you're relying on, since these exact guns weren't in existence at the time of the founding, but you need not a twin, but an analog, is there's arguably a history and tradition of banning unusual guns. We could add dangerous to that if you want, right? Dangerous and unusual guns. And so then I think that means, okay, well, we need to find a history of that and a tradition of that. History being, we need to look to the founding era, or maybe if we're in 14th Amendment incorporation world, 1868 era, but we're not here. Say, okay, do we see founding era, colonial era bans of guns in that are unusual? And if so, is there a tradition of it? Is it an outlier or is it kind of widespread? And let's say that I'm with you, that there is a tradition, history and tradition of banning guns for the purpose of preventing gun violence, a tradition of banning guns that are unusual, dangerous and unusual. Then you still have to show that this arm in question is unusual, right?
Well, I think I would have a disagreement with how you're characterizing unusual. If you're using unusual in the colloquial sense, that is it numerous in society? Are there a lot of that weapon? Then I would disagree with that's the way that this standard has to apply. And I think the problem with that is, first of all, it doesn't comport with the historical tradition. Bowie knives, I think, were quite popular and numerous at the time that they started to be regulated in the 19th century. Nevertheless, nobody thought there was any Second Amendment issue there.
They weren't banned, right?
They were eventually banned in a lot of jurisdictions by the end of the 19th century. I agree that some of the earlier restrictions are carry restrictions and other sort of severe regulations on those types of weapons.
With dueling.
Yes. No, that's right. But I think it cannot be that unusual is simply a sort of a redo of the numerosity analysis.
Well, it's not a redo if we're talking about something like banning unusually irresponsible people from having guns, because that's we're not talking about whether the guns are usual or not. That's a totally separate inquiry. But when the tradition that you're talking about is a tradition of banning dangerous and unusual guns, then I do think that that inquiry is going to be very similar to that first inquiry of, is the gun in common use?
The problem with that, I think, Judge Walker, is that I'd point the court to the Seventh Circuit in its decision in Friedman, pre-Bruin admittedly. It noted that machine guns were all too common at the time in 1934 that the National Firearms Act passed. Nevertheless, the Supreme Court told us in Heller that it would be a startling, and that's a quote from the decision, proposition that those types of weapons, the same is true for short-barreled shotguns, that any of those types of more militaristic, offensive, high firepower types of weapons or weapons accessories couldn't be banned.
I take it the Seventh Circuit said that, but my impression is that the machine gun was not the standard quintessential weapon of self-defense at the time it was banned. That it was actually Congress stepped in at a time when it was still pretty unusual, if you weren't a mobster, to have a machine gun.
I understand that, Your Honor. I think I have two responses to that. The first is, I think around that same time, there were actually a number of different bans on large capacity magazines that went into effect as well. We obviously quibble with our friends on the other side about which one of those count as bans or not, but I think at the very least.
Which one do you think, what's your best example of?
I think
not just a carry ban of a high capacity magazine, but a total possession ban of a high capacity magazine outside of DC.
Rhode Island, Michigan, and Minnesota, all reading the plain text of them seem to me to be bans on large capacity magazines. Ohio and Massachusetts and Virginia all had regulations of them in various ways.
I thought that Rhode Island, Michigan, and Minnesota combined the magazine cap with the mode of fire. So for example, a high capacity Winchester, like lever action rifle, would not have been banned by those states, but they would be banned by DC today.
I'm not sure that's right. I think there's an or in the Rhode Island provision that makes it seem like it's either or, either a certain capacity or automatic feature. So I don't think that's quite right. A couple other examples I'd point to would be that the model code for machine guns that was circulating at that time.
Those aren't statutes. And even if I give you Rhode Island, Michigan, Minnesota, didn't Bruin say 3 is not enough? Probably 4 is not enough, 5 is not enough?
Well, I think the problem here is that it would lead to really absurd consequences. It would mean that if the National Firearms Act had been passed in 1954, 20 years later, which could have been a reasonable response, Congress might have thought, let's let this percolate, let's let states decide, and then make a decision. In those 20 years, if a number of machine guns, far more machine guns had circulated, which I have no doubt that they would have, suddenly plaintiffs would be coming in and saying, hey, Second Amendment now comes in, and the scope of the Second Amendment has now
It
changed.
actually seems like a pretty decent proxy for what's dangerous and unusual. If it's dangerous and unusual, we would expect our legislatures to step in and ban them before they become dangerous and usual.
Again, I think I would just reject that type of circular argument. I think it means that it sort of puts the cart before the horse, and it incentivizes, in my view, over-regulation by governments. I mean, it basically means that governments, if they want to try to ban a particular weapon but don't know the societal consequences of it at the time that it comes on the market, governments would really be incentivized to come in and say, you know what, we're going to just ban this now, because we know if we let too many of those come out, if we let more than 200,000 or 700,000 enter into circulation anywhere and in any state, in any part of the country, we are going to be forever precluded from dealing with that weapon, from regulating it heavily or banning it down the road if we find that that weapon, does lead to really serious consequences, which we would say large capacity magazines have. And I'd add,
There also, I wonder if there's a circularity or catch-22 or whatever it is. If something gets out and is, for example, like the automatic guns, and automatic machine guns used by criminals, is there not likely then to have a reaction? And let's say that when they come out, they're deemed to be quite dangerous in a constitutionally relevant sense, in a way that firearms otherwise normally in civilian use are not. But once the bad guys have them, people want to have the same thing to protect themselves. Nobody wants to go up against a machine gun with a 6-shooter, right?
correct.
And so there's equally a risk that the response by people is not that we only need these for self-defense because the government has let them out there, and if the government doesn't let, or at least enough that like criminals have them. And so I don't know how any of this allows us to make analytical questions about what people really want for self-defense or desire or need. If there's simply this endless response to someone else has something more, manufacturers put out higher magazines, I need a higher magazine. It's like new iPhone comes out, I got to have a new iPhone. New magazine comes out, I got to have a new magazine. And so as an inquiry, how do we do the inquiry then about whether they're used for facilitating self-defense without it turning into an endless, well, if criminals have them, I should have them facilitating my self-defense too, so that we now have automatic weapons and before long grenade launchers in everybody's house.
I totally agree, Judge Millett. I do think that there is an arms race that would develop if the only standard is what people sort of feel they need to respond to certain criminal activities. So this is why we've we've made the point that in our view, the standard is essentially what is in fact commonly used for self-defense. And I think you can look at that in a couple different ways. You can look at it like Heller looked at handguns. What are the actual characteristics of handguns that make them useful for self-defense? They can be grabbed quickly in a self-defense situation. They can be held with one hand while you call the police. On the flip side, you can also look at how are large capacity magazines or any firearms actually used in self-defense situations. And on this, we've put evidence in the record that has been unrebutted by plaintiffs at this sort of preliminary stage without much evidence in total, that really in the average self-defense situation, 2 to 3 bullets are fired. It is rarely, if ever, that more than 11 bullets are fired in a self-defense situation. Now, obviously, these are sort of proxies for trying to determine what is in lawful use for self-defense, but we think they're objective measures of that. It cannot be that it's just a subjective test, because subjectively, citizens may decide they want a machine gun for self-defense, they want a grenade launcher for self-defense, and they may really subjectively believe that that is making them safer, that having that in their home and having it at the ready is making them safer. That would sort of lead to a rudderless test that would just be whatever weapon is most popular.
Because everyone's talking about standard issue, which I assume means that's what the manufacturer puts with it. When
Correct.
did manufacturers start selling magazines over 10
My
with the semi-automatic handguns?
My understanding is
Handguns
that
only.
semi-automatic handguns were not equipped with large capacity magazines until at least the 1980s, and I don't think plaintiffs dispute that. So it is quite a recent development that semi-automatic handguns, not rifles, were sold with or generally could even take a large capacity magazine. And you really see when that happens in the 1980s, which is a very recent vintage, that leads almost immediately to sort of what has become the modern scourge of mass shootings. And very quickly thereafter, in 1989, California imposes a large capacity magazine ban. Right after that, in 1994, the federal government imposes a nationwide large capacity magazine, which I might add is the 10-round number that the district uses today. That was in effect for 10 years. The moment it went out of effect, a number of states have slowly sort of adopted those bans as mass shootings have continued to happen across the country, usually using a large capacity magazine. I mean, that is in the vast majority of cases, maybe all of them, a large capacity magazine is used. And the reason for that is because it has a particular capability. I would agree with the colloquy with my friend that basically it's not a ban on weapons per se. It really is just a limitation on the total firepower that somebody has before they need to reload. So after firing 11 rounds with a 10-round magazine, a person just needs to take a few seconds and switch out the magazine, and they can fire 10 more rounds.
There's any limits on the number of semi-automatic handguns with 10 plus magazines that they can have?
The number of magazines?
The number of magazines and the number of handguns that can go with it?
No,
So they-
there's no such restriction in the district. You can have.
There is evidence here. It's in the declaration of Mr. Kleck that mass shootings with large capacity magazines are in fact a very small proportion of the mass shootings.
That's fair enough, Judge
Well, it's
Ginsburg.
contrary to what you just suggested a moment ago.
Oh, sorry. What I meant to say was that all mass shootings are conducted with large capacity magazines, or at least most of them.
Well, that's what
Not
I'm
that
saying.
all.
No, his numbers show that that's not true.
Oh, all shootings where 10 or more people are killed. These are like situations where there's a mass casualty number are by and large used with large capacity magazines. I agree.
The standard definition for mass shootings is 4 or more fatalities, right? Or maybe it's victims, but
Certainly, many of those there were not large capacity magazines used, but I do think that
it's not vanishingly rare, but it is certainly the unusual situation.
that's
In the most recent years, 21 going back, 5 of 28, 0 of 21, 4 of 31. These are outliers.
I think, we certainly would dispute some of those numbers. I think many of those
Did
experts,
you have anything contrary to that in the record?
not in the record, because all of their declarations came in and attached to their reply brief below. So we actually didn't really have the time for the chance.
Which numbers would you dispute that Judge Ginsburg read?
My understanding is that many of the really mass shootings that have happened over the last few years were that large capacity magazines were used in those cases. But I'm not sure that that's sort of critical to our argument and if the court.
Makes sense if you've got a gun that's got 4 to 6 in it and there's 4 fatalities. But once you start, as you said, if your statistics, or if you believe their statistics are so, when there's more than 10 magazines, there's more than 10 deaths.
Well, I think that's exactly right, because it's much longer before a person needs to reload. And it's that moment where a person reloads that is a time when law enforcement or bystanders can come in and intervene. So that's really the purpose of this law. But I guess the basic point that I was trying to make here.
You have that in the record. Wasn't that your evidence?
Yes, and I think the basic point I'm just trying to make here is that, you know, at the end of the day, this is a judgment call. The legislature is trying to draw a line, and I took my friend on the other side to essentially be saying that the legislature can draw a line somewhere. That line, you know, they obviously want that line to be higher than the line that we've drawn, but they're not suggesting that we can't ban some large capacity magazines.
They are offering a criterion, which is to say common use.
That's absolutely correct, Judge Ginsburg, and we are also offering a criterion, which is common use for self-defense, which
Well, wait a minute, we also have a declaration showing that 65% or something like that of people who have large capacity magazines acquired them for purposes of self-defense.
But again, I don't think that it can be a subjective inquiry. I don't think it can just be that people feel that they
Then
want.
you don't really accept the common use criterion.
Well, I think it's common use for self-defense in an objective sense. I think the test has to be objective and looking at the real world situations. Is a large capacity magazine actually commonly used in self-defense situations? We say the average number of bullets fired is 2. We also say that nobody needs the firepower where they can fire 11 rounds. And then all they have to do under our law is change out the magazine, which takes a few seconds. They have not put forward any coherent theory for why they need more than 11 rounds before simply having to change out the magazine in self-defense situations. And I just don't think that is consistent with the record.
It sounds, I mean, your argument is sort of that this law would go from being constitutional to unconstitutional once crime gets so bad that people start shooting more than 2 bullets self-defense a lot.
Well, I don't think it's quite that. I think, well, first of all, 2 is obviously far less than 10. But in addition to that, I think we're just trying to sort of come up with proxies for trying to understand how to objectively ascertain whether a particularly lethal weapons accessory is actually useful for self-defense.
What do you make of the civilian marksmanship program that I think started in the 60s? Congress, I think, through the program, the government gives away rifles with high capacity magazines. And I think it's been distributed to something like 250,000 high capacity magazines have been distributed. So, I mean, it seems like that suggests not only is there not a tradition of banning high capacity magazines, there's actually a tradition of the government providing people with high capacity magazines.
So I do think that there is some birth for governments to make different policy choices. The federal government in 1934 enacted the National Firearms Act, you know, severely restricting a whole swath of particularly dangerous weapons. If it made a different choice for a different type of weapon a little bit later, that's their prerogative. Would
you agree that there is a tradition of the government providing some high capacity magazines to people?
There is some historical evidence, yes, but I think that's
Were those rifles or handguns?
rifles. They were not.
And your
Which is not before us on this.
and your statute bans rifles, right? High capacity magazines for rifles.
Correct, though, at this preliminary.
Is it the only statute in history that bans high capacity magazines for lever action and bolt action rifles?
I don't know the answer to that, Judge Walker.
You know of any other statute that does?
Not off the top of my head, no.
And this certainly has sort of a sorry, I don't want
I just wanted to say, I don't think it has been applied to a lever action rifle as far as I'm aware, and that really hasn't come up before. So I'm not exactly sure in what ways it would apply to that. So I don't want to sort of overstep on that.
But we also have no record on rifles before us for the PI stage.
Correct.
We developed a trial.
That's exactly right. And not only that, my friends on the other side have said, it is unrebutted that all of the semi-automatic handguns that they possess do accept 10-round magazines and that they have 10-round magazines.
My point on the rifle is a larger point. I think the really, really 10,000-foot test that comes out of Bruin is can't be an outlier. And your law seems like an outlier, right?
I think I would just push back on the notion that whether or not a state is an outlier is the relevant standard, because what that would mean is that the first state to act just can't do it under the Second Amendment. It has to be that states can sort of experiment within the bounds of the Second Amendment, of course, but McDonald made very clear that all experimentation was not off the table. And some
that would be a pretty good argument against the way the Supreme Court has done Eighth Amendment analysis, right?
Fair enough, Judge Walker. But I do think that the idea here is that states get to respond to local needs and local circumstances. They have some birth to make these decisions. We take this 10 number as a policy decision that is based on a history stemming back to 1994 when the federal government imposed that restriction. Firearm manufacturers then responded by creating 10-round magazines for all of the semi-automatic handguns that are in widespread circulation today. So I do think there's sort of been a coalescing around that number.
Unusual under the Eighth Amendment, the same as the Second Amendment? I thought they were different.
No, they are different, Judge Millett. And we would sort of, the dangerous and unusual phrase, we really think is a term of art. It cannot just be that unusual is a standalone numerosity requirement, as I've already discussed.
Can I ask about the three factors after likelihood of success? I know your brief says that even if you were not to prevail on likelihood of success, that we should still deny the PI based on those factors. I wonder how the harm to the district should be thought of if we, I'm not saying we will do this, but if we were to find likelihood of success for the plaintiffs and limit the PI to the 4 plaintiffs. It seems very unlikely the district is going to be injured by these 4 plaintiffs unless you have some reason to think they are, perpetrators of gun violence.
I agree, Judge Walker. If the court were to limit the PI to only these plaintiffs, the harm to the district would not be as significant as what we have said in our brief would happen if the court enjoined the law across the board.
Right?
I think it would be minimal. The only problem with that is I'm not sure why every other plaintiff would come in immediately thereafter, and it would just sort of result in this sea of litigation. And then eventually you would get, obviously, to a place where we think large capacity magazines would flood into the district. And this really happened in California. I mean, the plaintiffs have put forward no contrary evidence or rebutted the fact that for the 1 week in California where a district court judge did enjoin their large capacity magazine, 1 million large capacity magazines flooded into
I mean,
California.
it sounds like that means large capacity magazines are in pretty common use.
Well, they're certainly popular, Judge Walker, but I think, I've
Can I ask
explained
one
why.
more history, not necessarily one more, but can I ask a history? Can I go back to the history inquiry? Do you read the Prohibition era laws to permit you to ban every semi-automatic firearm?
No, I don't.
I think you have to say no because of Heller.
Correct.
And then if not, why do those Prohibition era laws permit you to ban every firearm with a magazine above 10 rounds?
Well, so I think that sort of goes to the burden aspect, right? So when you're in this world where, because of dramatic technological changes, you're looking for a historic analog and not a historic twin or a dead ringer, I think in that world, you're then looking to whether or not the prohibitions from earlier eras have a similar burden on individuals' right to self-defense and were enacted for similar reasons. And the similar burden inquiry, I think, is why you can sort of distinguish those two things. In our view, really, our law allows individuals to have semi-automatic handguns with magazines up to 11 rounds and as many magazines as they want and as many handguns as they want. All it's saying is that when you get to the 11th round that you fired, you have to take a few seconds to change out the magazine, which I don't think affects self-defense, minimally, if at all. But in an offensive situation where a person is trying to commit sort of mass murder, those few seconds can be the difference between life and death. They're the time that a police officer can come in and intervene, or a bystander. There's evidence of that happening in the real world.
And I think that is an eloquent way to frame the current regime. I think an alternative framing would be, you didn't used to give citizens any of those rights. It took a lawsuit in the Supreme Court for them to get what you're saying you now sort of so generously give them. The reason the Supreme Court ruled against you then, 10,000-foot inquiry, you were an outlier. Look at it today, you're still an outlier.
Well, I think I might push back that today we're an outlier. There are actually a number of jurisdictions that have these requirements in addition
How many
to federal.
jurisdictions ban high-capacity magazines for all guns?
I think it's 14 these days, which covers actually close to, I think, maybe 40% of the American public. But in addition, the federal government banned these from 1994 to 2004. But even putting aside, let's say we are an outlier on this to some extent. I don't think that what Heller said was simply look at the jurisdictions. The district is out of line with other jurisdictions. End of story. That would have been a very short decision. It is much more complicated than that. And I do think when you're looking at the historic justifications, we haven't really talked about this too much, and I know I'm over my time.
Real quick though, the national ban, did that apply for high capacity magazines? Did it apply to handguns?
My understanding is that it was all large capacity magazines, but I could be mistaken about that. And you know, on the dramatic technological change, I do think this is just a substantial change from anything that existed in the 19th century. Even as late as the 1870s, you had 0.2% of all firearms being able to fire multiple rounds. It wasn't until the 20th century that machine guns came on the market, and it wasn't until the 1980s that semi-automatic handguns could take large capacity magazines and sort of that started to proliferate into society. So I do think there's really been substantial changes here that justify this kind of regulation, and that the regulation minimally affects the Second Amendment right, and we hope the court will affirm. I'm happy to address any other.
In Heller 2, we said the prohibition of semi-automatic rifles and large capacity magazines does not effectively disarm individuals or substantially affect their ability to defend themselves. Now, we said that in the section of the opinion that was doing intermediate scrutiny, so that definitely would not work for the merits inquiry. But when we're at the preliminary injunction stage trying to determine irreparability of harm, does a decision by this court, including, it was on that record, but I don't know the material differences here, that the prohibition of large capacity magazines does not effectively disarm individuals, or more relevantly here, substantially affect their ability to defend themselves?
That language is highly persuasive, I think. I don't think I can say that Heller 2 is binding on this court. It applied means and scrutiny at the end of the day.
Well, that's why this language, I thought we
correct, which
the front end part of it probably is still binding on this court.
Correct, exactly, right. So
and then also part of the back end, so definitely not right for the merits, but said on that record at least, there was hardly any evidence that these magazines holding more than 10 rounds are well suited or preferred for self-defense or sport, but we're only talking about self-defense here. Is the record different in this case?
That
they are preferred for, well suited to or preferred for self-defense?
Well, on the preferred standard, as to preferred, I think that is sort of like a popularity type test. And so I think we certainly don't dispute that there are many of them out there and that they are popular. On the well-suited, we certainly believe that they are not well-suited to self-defense because—
Is there popularity difference? So this was 2011, so that's, you know.
I don't think it's—
the popularity changed between 2011 and 2020?
There are more of them, but I don't think that as a legal— I don't think there's a legally—
Well, I'm trying to read what preferred meant. Yeah, I should ask him, I know.
Yes, Judge Ginsburg might have a better sense of what that meant. I sort of read that to be more of a popularity type standard, but I do think that the well suited for is sort of a good way to think about what Heller said about handguns and contrasting that with large capacity magazines, which we think are quite ill suited for self-defense purposes.
Thank you very much. Okay, Mr. Wenger, we will give you 3 minutes. Sorry, I know you want to, we have other.
That's no, I completely understand that, Judge Millett. So a few points that I want to make.
Before you do that, do you have the answer on how long they've been residents?
Oh, I actually did not grab that. I'm so sorry about that. So
Can someone whisper it to you?
Yeah. Yeah, I want it.
I heard 1980 something.
Since 1988.
1988, okay. Sorry, since 1988. Okay, sorry, go ahead.
So going back to the start, quoting Heller, the Second Amendment, whatever the reason the American people choose to put something in common use, whatever the reason, a categorical ban on a commonly used arm cannot withstand Second Amendment scrutiny. The Americans do get to decide what's useful. It's not a subjective test, and the objective inquiry is whether or not.
Popularity test?
They say whatever.
I'm really struggling.
It's not a popularity test because objectively you can look and see what it is that America decides to arm themselves with for purposes of their self-defense.
How do we, this is just a fact question. I really don't know how this
Yes.
works. I get that we know handguns are used for self-defense. That's just easier for a lot of reasons. Your friend on the other side even mentioned it's accessibility, usability. How do we know that when folks are buying 10+ magazines, that was for self-defense. That is, that say they had before it, they had a 10 number magazine, 10 bullet magazine, or an 8. And then now they've purchased 16.
Mhm.
How do we know they did that to facilitate their self-defense?
We've put in the record that 64% of the people who own these plus 10 magazines have bought them for the purposes of self-defense.
Was there a survey that's?
There was a survey, Your Honor.
And that survey was done when?
Recently, I think it was 2021, I believe. So this is
The
recent.
totals in that survey are well over 100% because people had multiple reasons.
Correct, yes. They have multiple reasons to do that, but of the highest, 64% of the people who have owned this in that survey said that they own it for purposes of self-defense. And these are.
They own the magazine or they own the handgun?
They specifically owns the higher capacity magazine, the ones
So
that are
they
manned
had
by the district.
Smaller magazines? Or
I don't
no
know
mag-
if-
No weapon at all, and then, so I'm
I-
just trying to figure, because if the manufacturers are pushing these things out with the higher magazines, so that when you go to the store, that's just sort of what's on the shelf. It's hard to understand
Well,
these.
respectfully, Your Honor,
Maybe this is
there's-
too much factual stuff.
I mean, respectfully, there are, in some jurisdictions, you can legally buy 50-round magazines. Those are not in common use for lawful purposes because the American people have decided they don't use those for common
But they
purposes.
decided prior to the 1980s that they didn't use magazines over 10 for self-defense.
No, Your Honor, as soon as they became available,
But that's like the iPhone. As soon as it's available, I want the newest one. But if they're, I mean, I didn't see anything in the record where your client said that, or you had any evidence that someone wasn't able to defend themselves with 11 or less bullets.
that I think, so there is evidence in the record, and this is the Warner Declaration, paragraph 10. I've got the app site here, I can pull it up in a moment. But they basically said that these, even though they're not the typical self-defense, not that there's any typical self-defense incident, but they have
Someone
occurred
said
with
even though
people.
they're, okay, go ahead.
These have occurred. There is a record that these actually have occurred where people have needed more than 10 rounds.
Where's
And
that?
It's
Hey, what?
the Warner Declaration. It is at appendix site 746, and it's paragraph 10.
But is that common use or has it just been a few times?
I want to make sure that I answered that question
Mhm.
in the context of
Right,
the Second
sure.
Amendment. In the context of the Second Amendment,
Mhm.
limiting the rights of self-defense to the very act of pulling the trigger cuts the protections of the self-defendant basically down to 25%. Heller itself defined the term bearing arms as not only pulling a trigger, but wearing, carrying, making sure that you are prepared for whatever happens, no matter how rare. It didn't say prepared for whatever happens in the common situation based on the
Where is it on page
statistics.
746?
Paragraph 10, I believe.
Paragraph 10. Well, the average citizen defensive gun use involves no rounds fired.
Mhm.
Where does it say? Oh, it just says there were situations where citizens fired more than 10 rounds and needed to reload their firearms. We don't have any sense of how many that is. We don't have any sense of.
No, we would concede that it's more rare than the evidence that's in there, but it does happen. And the right to bear arms is to be ready for
Mhm.
the unusual situation. The point about most self-defense uses not involving a shot at all really emphasizes the inappropriateness of that particular study. In most self-defense circumstances, pulling out a weapon and brandishing it will scare off somebody else,
Regardless of the magazines.
regardless of the. So based on that alone, if that reason tracks, you could ban all guns. You could ban all magazines because they are quote unquote not commonly
We're just at
used.
a preliminary injunction inquiry here and irreparable harm on their right to self-defense. That's the only context in which at least I'm asking these questions.
Correct, yes. And their harm on self-defense is that they are not allowed to bear a weapon to be prepared for that unthinkable circumstance where they might need to use more than 17 rounds. We're pausing to reload.
More than 17 now?
I'm sorry, that was a misstatement.
Okay, sure.
More than 10, no. Excuse me, more than 10 rounds, because pausing to reload for even those few seconds could mean the difference between life and death. That's the decision that the Second Amendment allows them to make. And I think that the really important quote from, from Bruin
Well,
about
I
that.
should have asked DC this, but this is along the lines of your discussion about how many shots are fired and how often that is for but the military serves a national defense purpose even when we're not at war, right?
Correct. Yeah,
Is there an analogy there to your?
absolutely there is. The ability to be prepared for the rare circumstance is covered in the very definition of what it means to bear an arm. It certainly is covered by the separate protection, the ability to keep an arm. And Heller made very clear that those are two distinct protections. So limiting the inquiry to the very act of pulling a trigger basically wipes out 75% of the plain text of the Second Amendment.
But insofar as we're looking at balances of hardship in the PI context, the imposition on, or the burden, I should say, on the Second Amendment right as you're claiming it would seem to be quite minimal because of the rarity, because of the district's point about the rarity with which a person in a defensive situation actually uses more than 11 rounds.
I still think that what we're talking about when we're talking about life and death situations and the ability to prevent those, on the very facts of it, that risk is irreparable. And I would submit to the court also that even on a PI, this court has held that the invasion of a protected constitutional right is itself irreparable injury. I believe that's Roman Catholic Church versus Cuomo. One important.
Well, but there is, I mean, we are instructed to take account ordinarily of the burden, but even more specifically under Bruin.
Oh, correct. And so the imposition, the actual threat to the right here is the ability for my clients to bear an arm that they've decided is necessary for their self-defense purposes. It's, again, I'll emphasize, this is a right that pre-exists the Constitution. This is something that's part and parcel of being a United States citizen. Heller stands for the proposition that the American people, to Judge Walker's question to my friend on the other side, they are the ones, they are trusted to make these decisions. They have decided that these particular semi-automatic, higher capacity magazines are useful for self-defense. In the 1920s, they decided automatic weapons were not. They do make these decisions and they make them responsibly. One thing about that I really want to emphasize, I think that my friend on the other side is really arguing that we should defer to the judgment of the district about what is and what is not most useful. Bruin squarely foreclosed that, and I'll quote the language. While judicial deference to legislative interest balancing is understandable and elsewhere appropriate, it is not deference that the Constitution demands here. To the question that Judge Walker asked, the test itself from from Bruin, which they reaffirmed, is when the Second Amendment's plain text covers an individual's conduct, it presumptively protects that conduct. So that means that the very first thing is if the protection is to keep and bear an arm, if you have an arm, it is presumptively protected. If the government cannot prove.
You should wrap up here. We've actually given you
Absolutely.
more than your 4 minutes.
Certainly. If the government can't prove a history and tradition, it can't categorically ban that arm. And the fact that something is commonly used for lawful purposes means that there is no history and tradition of banning that arm.
Thank you
Thank you,
very
Your
much. The case is submitted. Always happy to be here.
Case number 23-7009, et al. YO Technology, Inc. versus Republic of Iraq and Ministry of Defense of the Republic of Iraq, appellants. Mr. Morag for the appellants, Mr. Katyal for the appellee.
Good morning, and may it please the court, Boaz Morag for the Republic of Iraq and the what we call IMAD, the Ministry of Defense. I've reserved 3 minutes for rebuttal. I'm happy to answer any questions the panel has with respect to the damages and issues and the cross appeal, but I would like to focus my remarks on the grounds that we think are the most straightforward ones for that mandate reversal, which is that the district court erred in holding that IMAD's failure to pay the invoices that YOC instructed be paid in Baghdad had a direct effect in the United States under Clause 3 of the Commercial Activities Exception of the FSIA. This is, as you know, a straightforward breach of contract case. The contract, the broker services agreement, was pitched by YOC to IMAD in Baghdad, entered into in Iraq solely between YOC and IMAD, and was for Iraq to refurbish or sell for scrap military equipment in Iraq. It is governed by Iraqi law, and the Iraqi defendants had no contact whatsoever with the United States. And importantly, the BSA did not require or even contemplate any performance by Iraq or for Iraq in the United States.
Well, let me ask you about that. In the letter accompanying Iraq's execution of the agreement, I'm quoting, "This program will be administered with the assistance and cooperation of the United States military." Why isn't that sufficient to show there would be some performance in the United States?
Because what that is referring to, Your Honor, is the assistance in Iraq, because the United States...
Well, the United States military authority is here. Right? Whatever happens in Iraq is going to be subject to direction from the United States.
But the specific reference there to the bases where the Iraqi military equipment was located. And this is part of the transition from Iraq, from the coalition that had invaded Iraq and occupied it, transferring sovereignty back over to Iraq. Yes, there was a need for access that the Iraqis and YOC needed to the Taji and Muqtadiyah and other military bases. This is not a direct effect on the United States based on the standard that the Supreme Court in Weltover and this court in IT consultants and cruise connections required: an immediate, unavoidable, or inexorable consequence. And that has to be felt in the United States. The other thing...
It's also provided that notice to be given of any circumstances was to be given to YOC in Pennsylvania.
Your Honor...
Probably because something was going on in Pennsylvania.
No, that was simply where YOC, as any U.S. plaintiff might be, had its address. No one has ever in the history of the FSIA relied on a notice provision to suggest that there is no claim here about the failure to give notice.
Evidence that Mr. Stoffel was doing things in the U.S. in furtherance of the performance of the contract.
But that is the theory of the first judgment that was reversed by this court 2 years ago this month. That performance was not required by the contract, and so therefore it's not attributable in any way to Iraq. Where a U.S. contractor chooses to pursue administrative tasks which are not specified as either required or necessary under the contract cannot create a direct effect in the United States. Recall that you've already decided that this case is simply the act for purposes of 1605A2 for the direct effect exception is the non-payment of the invoice. That is the act that resulted in the failure of money that was due and owing in Baghdad to be delivered in Baghdad. The question is, what is the immediate, unavoidable, and inexorable consequence of that act And did it occur in the United States? The district court agreed that there was a direct effect in Iraq, but erred in finding 3 other direct effects in the United States. And the reason that that's an error is because what the court found is not the immediate consequence, and an immediate meaning without interruption or intervening act, as Your Honor wrote in the Prince case. It has to logically follow that there is no way of avoiding this harm. And what the trial court relied on was Wye Oak's reaction to the harm. Wye Oak did not receive money in Iraq. That's a financial harm to a U.S. Company that the Valambia case and many others say is not sufficient to create a direct effect in the United States.
There was letters, like Iraq paid Mr. Zaina, and then Mr. Stoffel directed Mr. Zaina to pay that money into a U.S. bank account.
So
Why
that is
that not, because you know, the Supreme Court has recognized, even in Weltover, that funds that are supposed to go into U.S. bank accounts and don't are in a direct effect.
Yes, Your Honor. That is the argument that the district court rejected, that Wye Oak has raised on appeal. The reason that the district court got that right is because the contract let Wye Oak specify where it was to be paid. It specified Baghdad. It insists to this day, and this court and the district court previously found that the breach occurred on October 28, 2004, when those invoices were not paid, and they were paid immediately upon presentation. Subsequently, Wye Oak sent an email to Mr. Zaina asking for a piece of that money to be paid to it in the United States. There is no case in the history of the FSIA that permits a plaintiff to, after the breach has occurred, change the place of performance to the United States.
The breach is either ongoing or repeated breaches here, because Iraq chose to send the money to Mr. Zaina instead of to them. And at that point, their ability to direct the form and manner of payment, they were responding then to what Iraq had done. And you know, the complaint itself has a more sort of comprehensive view of what the breach is in this case. What the contractual, by not paying these invoices, they breached their agreements. Their agreement, which was both in the contract, August 30 amendment, reaffirmed in Baghdad in December. So they're reviewing this contract and the obligation to pay as sort of an ongoing duty on behalf of Iraq until it actually did pay. And if its theory was, well, we paid Mr. Zaina, and they said, fine, send that money to the United States. So it seems
But Your Honor,
complicated to me to say, no, there was just one breach, and then all their efforts after that to get the money aren't relevant. You see, there's no case. There's a case saying the opposite, that subsequent efforts to direct the money are irrelevant for FSIA purposes?
all the cases say that the election of the United States has to be provided for in the agreement or agreed to by the sovereign before the failure to pay.
But here the sovereign agreed, we'll pay wherever you tell us to pay.
Yes, and
If they had said at the first point, pay us, so if the contract is written exactly as it is, and their first choice was pay us in the United States, here's a bank account in the United States, send the money there, would that satisfy Weltover?
yes,
Okay, so then it doesn't have to be expressed in the contract. It has to be expressed by,
well,
here, at least under this contract, it has to be expressed by a broker, which is Wyoke, and they expressed it when Iraq misdirected the money.
Your Honor, several things. First of all, I misspoke. It would be acceptable, it would create a direct effect if, when Iraq got that instruction, it agreed to do so before it decided not to pay. But the point here is that there's more than just the issue of the sequence. What distinguishes this case from every other where the person is owed money abroad and then comes back here and asks for it in the United States. The breach occurred where the contractual obligation existed. The FSIA and the Sachs decision by the Supreme Court require the plaintiff to identify the gravamen of its claim. And the gravamen here is that these invoices were not paid. Every piece of damage that is the second half of this appeal, they're still to this day asking for interest to accrue as of October 28, 2004. That's their choice. But if that's the claim that they've asserted and that the district court ruled on and they're still pursuing, that has a consequence for the based upon analysis, which is what is it based upon? The act. It has to be based upon an act, and that act has to create a direct effect in the United States. And so besides the issue of being able to change the place of payment after the breach, you also have the fact that, well, it changed again after that. So the point is that in December, they had the meeting which was changed to you will get paid in cash in Baghdad. So the only place that on this record, Iraq ever agreed to pay, because there's this entire issue that the district court did not address, that we raised over Zaina's authority to act for Iraq on November 25th, 2004, the date he received the email, and the day after he responds, I don't have the authority to pay you or to pay me. We need authorization from the Ministry of Defense. So on this record, and that did not come, this part is undisputed, until the December 5th all-hands meeting in Baghdad.
Can I ask you a question about Odhiambo?
Sure.
It doesn't, I think if I remember right, it does not discuss McKesson. And
It does not cite McKesson.
right. Do you have a theory for why?
Because I think McKesson is sui generis, as you made clear in Helmrich and Payne. McKesson is not a commercial contract case. McKesson is a case involving essentially an expropriation. And so what Iran did in McKesson, which Iraq did not do here, is it wasn't an issue of not paying. It was an issue of directing the dairy in which McKesson was an investor, that it would no longer deal with McKesson as a counterparty on a technical services agreement, receive the goods and services that McKesson regularly sent over so that this dairy would create profits.
I know what McKesson says. And it sounds like your answer, which may be the right answer, is that Odhiambo tells us what to do in a contracts case. There are other precedents that tell us what to do in, let's say, a torts case. It's like the Venezuela fraud thing. And then McKesson maybe tells us what to do in a takings case or an expropriation case.
Well, that's partly it. We're not standing on a categorical distinction. We're as to this is a contract case versus a tort case. We're just we're putting before the court the precedents that seem the most on point for the facts here.
So what about cruise connections? Judge Ginsburg referenced the fact that, as you say repeatedly, Breeze, this is a small company and it was a very big contract. And so they were going to have involve their employees here in the United States, their computer equipments, their invoicing, personnel here to help organize this very, very large contractual undertaking. How is that record here different from cruise connections?
Because cruise connections, the entire subject matter, the raison d'etre of the contract that the Canadians terminated was the acquisition of goods, the cruise ships, and services from the United States. In order to bid on the contract that cruise...
That's what that means, because this is a U.S. company, and so everything this contract was doing was going to be obtaining services, skills, logistical support from the United States, where WIOC is based. So that can't be the test. And there's nothing that I saw in cruise connections that required that contracting with the U.S. cruise companies be done in the United States. You could do that contract from Canada or anywhere else.
Yes, but the object of the contract was to obtain ships that were in the United States.
The object here is to obtain skill and ability and functional resources from a company in the United States. I'm struggling with these lines as to when what you're doing in the US matters and when it doesn't.
I don't see how you can reconcile your prior decision because you're attributing legal significance to whatever they did in the United States. That doesn't qualify. Nothing.
And what we did in Cruise Connections?
No, because in Cruise Connections, what the court said, may I answer?
Sure, of course.
What the court said was treat this as if you had a contract to buy $100 million of steel from a steel plant in the United States that the Canadians then terminate. That has an immediate consequence because you know that that steel has to be manufactured here because that's what the contract says. That is why the sovereign knows that it will have an immediate effect in the United States if it terminates that contract. Simply contracting with a US entity, Wyoke was not required to spend a penny of its own money. The object was clearly activity that would take place in Iraq. The choice by Wyoke to use the brother in Pennsylvania to hold the computer as opposed to an employee in Amman, Jordan to do it is not something that's attributable to the sovereign and cannot be seen anywhere in the contract. Those are distinctions that matter under your case law.
Ordiambo suggests that it need be expressed as long as it's implied or implicit in the contract.
But there is no activity that is implied in the contract. You can't say for every contract there must be some sort of back office because then you have eviscerated the direct effects test. Recall that when under the FSIA, which the Verlinden opinion in the Supreme Court tells us requires a substantial connection to the United States, the direct effect, the inexorable consequence is the only US connection. And so the fact that somebody in the United States chooses, as a result of not getting paid in Iraq, to stop certain activities is not consistent with this idea that this should be an exception and not swallow the entire rule of presumptive immunity that Congress afforded. There really are not that many, this is, in terms of the sequence of events, very much like the Helmrich and Payne, where you have there's a non-payment, there's nothing stopping you from continuing to perform. Wyoke does continue to perform until it decides when to stop, and it's entitled to do that.
Thank you very much. We'll give you a couple of minutes on rebuttal.
Thank you, Judge Millett, and may it please the court. Neil Katyal for Wyoke. I'd like to reserve 1 minute for rebuttal in the cross appeal. Wyoke and Iraq signed a contract. General Petraeus in our 8-day trial testified at the trial that Wyoke's work was a centerpiece of the effort to rebuild Iraq's military. Iraq refused to pay, even after Wyoke's president was brutally murdered. And after 13 years of litigation, the district court held Iraq was not immune and it breached the contract. Now, before this court, they're not contesting the breach, they just plead immunity. And last time this court recognized a plausible basis for a direct effect and remanded for factual consideration. The district court did that, calling this a quintessential example of a clause 3. That decision was right for 3 independent reasons, and notably, Iraq doesn't cite a single case reversing a district court's finding of a direct effect after a trial, not one, and they bear the burden of proof. The first reason is that the district court correctly held that Iraq's failure.
Can I ask a question based on some of the discussion with your opposing counsel? And that is, when it comes to the place of payment, I think Iraq would suggest that we look either to the time of contract formation or at the latest, we look right up to the moment before the breach. I assume, so you disagree with that, right?
I do. I don't think it's necessary here. I'll explain that, but.
Okay. I think part of the appeal of that is that you could imagine concern about FSIA waiver being a part of the bargain that was struck. And so if Oak had wanted and the effect of an FSIA waiver, then probably they would have had to given something up at the time of contract formation. And if we can allow a post formation or at the latest a post breach conduct to have the effect of an FSI waiver, then it seems like we're upsetting the bargain that was struck between.
Yeah, so I'd say three things about that. First, just as a matter of housekeeping, there are three independent direct effects. This bank issue is one, the other is cut off of flow, and the other is the military impact that Judge Ginsburg was pointing out. They have to run the table and win all of them because it's a direct effect is the language of the statute. The second thing is I think Weltover directly rejects, Your Honor, that formulation. Argentina's brief to the court at I think page 30 and 31 made a version of this argument and said this would open the floodgates. But what Weltover said is, look, there was first a breach, and then after that, the party specified the place of performance, the New York bank account. That's at page 610. And this court and IT consultants read it that way.
Was the contract there a pay anywhere contract, or was it you're going to pay in one of two or three or four places?
Pay in one of four places.
The U.S. was listed.
The U.S. was listed. Well, I think Judge Ginsburg points out that Valambia says you can have a contractual obligation or otherwise. So I think this court's already done that. And here, this contract, I think, for all the reasons Judge Ginsburg was pointing out with respect to the other piece of the direct effects, did contemplate a lot of U.S. performance. I mean, the whole question under direct effects is this an attenuated long chain of causation, or is this natural and predictable? This is a U.S. headquartered company. Iraq is a war zone. It's not unforeseeable or, something that is not natural and predictable to expect that United States performance would be
Whose
done.
decision
Would
was
you
it?
agree that the efforts to enlist congressional help and executive branch help is not a direct effect?
Yeah, I don't think that by itself. We're certainly not saying that. I think we are saying the kind of thing that you said, which is the letter at joint appendix page, the joint appendix page 486, that this contract will be administered with the help of the United States military in conjunction with the fact that this contract was all about standing up Iraqi forces so its U.S. troops could stand down. We had testimony from General Petraeus at this trial explaining that, as well as testimony from Brigadier Clements and Mr. Beadle. That's at Joint Appendix pages 1405, 155, and 1067. This court routinely defers to military judgments in all kinds of circumstances.
Where did they say that execution of this contract involved military officials in the United States as opposed to the military officials, boots on the ground in Iraq?
Well, I think what they said, and this is what the district court said, this is Joint Appendix 432, is, quote, unlike in the Prince case, there are no intervening actors that cut off the chain of causation between Iraq's non-payment and the impact on the U.S. military's readiness to leave
That's a
Iraq.
separate, so there's one, are you involving, the letter sounds like the military is going to be helping to execute this contract, but there's no evidence that actually any military resources located in the United States or military personnel in the United States were involved in the
I
execution.
think that
of the
Joint
contract.
Appendix page 429, the judge does say that, quote, that Iraq's breach had a direct impact on U.S. military operations directed from the United States. And as
No,
Judge
the
Ginsburg,
operations directed from the United States, how general were those operate? If it was, well, this slowed down the Iraqis getting self-equipped, which then slowed down removal of U.S. forces from Iraq many, many, many years later, that's a different thing.
yeah, I don't think that's what the testimony was. And I think it's reasonable to infer, as
Where's the
Judge Ginsburg
Go ahead.
was saying, was that, if there's an impact on U.S. military operations, if you're going to have to keep more troops there, which is what the testimony was, obviously that's going to be something directed from the United States. It's, after all, a U.S. military
Did General
campaign.
Petraeus say outright, we kept troops in Iraq longer because of this breach?
I don't think he quite said that, but I think the testimony of all of those officials together does say that, and that is what the district court found at the page I read to you before. And I think that is a clear finding by the district court.
There
They'd
were
have
a
to reverse
million
it.
factors that went into when we were able to.
And that's exactly what they argued at the district court, and that's exactly what the judge rejected after an 8-day trial. And I certainly don't think it's clear error. To go back to the bank account point, I just want to make one final point, which is Judge Millett's point about how this is an ongoing
duty to pay. And so it wasn't as if there was, only a designation afterwards. And the district court here said, look, the big concern in these direct effects cases is some opportunistic behavior. And I take it that's what you're getting at with the FSIA waiver point. And the district court rejected all of that on the facts of this case, saying that this was a contract that extensively required performance in the United States, that these opportunistic concerns don't apply at page 411.
My point wasn't that opportunistic behavior occurred here. My point was it would seem odd, I think, to create a legal rule going forward that would either incentivize opportunistic behavior or disrupt the bargain that was struck.
Oh, yeah. So no, because after all, the contract, anyone in the future, if they're worried about this, would just not agree to a place of payment clause, a unilateral place of payment clause, like the one that's in this contract. But these folks agree to that. So that is the third direct effect. The second one is the impact on the military. The first, we haven't even gotten to talk about yet, is the cutoff and the analogy to McKesson. And my friend's best argument on the other side is that it has to be unavoidable and inexorable. There is no case that says anything like that as part of the legal standard. It is true that there's an offhand observation in IT consultants saying that in that case, that it was sufficient to establish a direct cause if it was unavoidable.
On that point, let's assume that there was a cutoff of capital, personnel, data, and intangible services between the United States and Iraq. Whose decision was it to cut it off?
It was the natural and predictable result of Iraq. It's no different, Your Honor, than
Not when it was, whether it was foreseeable, or not, but who made the call? Somebody made the call.
Yeah, I think Iraq did. And it's just like, here's an example. I don't pay my electricity bill, okay? And the electric company keeps the lights on for a while, as they do, and then ultimately they turn them off. Nobody would say my lights being turned off is the result of the electric company. Yes, they made the
I think
final.
there's merit to that. I think that is different than McKesson, because in McKesson, like Iran was the electric company. They shut the lights off.
So I think that's actually not right on the facts of McKesson. You can play the exact same games about the choice. So this court in McKesson, this is a 271 F3rd 1104, said it was a U.S. company that made the choice to withdraw the U.S. personnel. Paragraph 35 of the complaint, which is in their own appendix at page 34, says McKesson made that choice really reluctantly. And indeed, they kept the personnel in Iran after nationalization because it was part of their duty to mitigate. And that's exactly what happened here. They didn't pay their bills. We tried to keep things going as part of our duty to mitigate. We couldn't do that ultimately for too long because, as the district court acknowledged, and the cites to this are our brief, pages 20 to 21, when someone doesn't pay, particularly when it's a small company in a big contract, you can only keep going for only so long. And it is that, as EIG says, which is a case that's buried in their reply brief, you look to what is the natural and predictable results when a foreign sovereign takes that action. The natural and predictable result of not paying these, these tens of millions of dollars is that.
I think you're going to disagree with this, so tell me why it's wrong. McKesson tells us what to do in an expropriation case. EIG tells us what to do in a tort fraud case. Odiambo tells us what to do in a contract case.
Yeah, I don't think that there are different standards for direct effects in each of those. I think the answer to your question about why Odiambo doesn't cite McKesson is because in Odiambo there was zero U.S. performance whatsoever. And that's why it didn't have any analogy to McKesson. Here, as Judge Millett was saying earlier, there's all sorts of stuff that is happening in the United States performing under this contract. If you look at volume 4 of the joint appendix, it's hundreds of pages about what's happening in the United States.
At the time of contract formation, was it kind of inevitable in the eyes of Iraq that those things would be happening in the U.S.? And one reason I ask is I think a lot of the equipment was probably Soviet era supplied equipment. So, if Iraq had to take a guess on who WIOC was going to be subcontracting with it, they might have guessed, Russian or Eastern European subcontract.
So two things, Your Honor. One is Cruise Connections directly forecloses that argument, as I think Judge Millett was saying earlier. It expressly says the foreign government doesn't need to agree in the contract to U.S. performance.
Any Cruise Connection, the American subcontracting was expressed in the contract.
Well, just the U.S. headquarter of the two subcontractors, which is of course true here. Paragraph 11 of this contract says WIOC is headquartered in the United States. So if we're going to
contractor, but not the subcontractor.
Well, I think if anything, that cuts the other way. Again, the whole
But
question
you have to
is.
come up with a rule that doesn't mean every time an American company does business with a foreign government,
Yeah.
that you win on direct effect.
Yeah, and that's certainly not our argument. If there's background.
For every small company.
Yeah, but I think here the question is, and here, as this case comes to the court, the district court made clear factual findings that with respect to this company, unlike in Helmerich and Payne, and where there was no factual development of this, but in this company, if you cut off funds, you were starving them of the capital necessary to perform the contract. That's what the district court said repeatedly, including at Joint Appendix page 421. And indeed, even this court.
That's not an effect in the United States. Starving them off from the ability to execute the contract in Iraq does not necessarily mean an effect in the United States.
Well, given all the ongoing performance that the district court isolated, it's direct. It's not a long chain of causation. It is the most natural thing in the world.
Were they on notice in the contract that they were going to be responsible for these activities in the US? Because it was this unusual contract where, as you said, they weren't laying out money. They're working with the military folks in Iraq. It was just an unusual contract.
Yeah, I'd say two things about the Your Honor. First is it's at least as foreseeable as in cruise connections, of which the only mention was a U.S. headquartered subcontractor. Here, of course,
getting U.S. cruise ships. And so that's gonna, if you're US based and you're supposed to make contracts for them with US.
well, again, I don't know that they're
ships.
supposed to be with the U.S. ships as part of the
My reading of
contract.
the opinion was US cruise ships.
Oh, they were U.S. cruise ships, absolutely. They turned out to be, just as here, even accepting your premise, it turned out to be performance in the United States. I think it stands to reason the contract itself recites Wyoke's extensive experience in the area and David Stoffel, and he's of course based in the United States. The second thing I'd say is it's not different than this court's decision in Dispel, which involved there wasn't even a written contract at all. Certainly nothing there saying U.S. performance. But Hungary had agreed to promise to return the art in that case to the Herzog family. Some of those members resided in the United States. This court found that enough to be a direct effect. And here, as this case comes to the court, you have the district court saying, look, this is natural and predictable. A contract's being performed largely.
Back to Judge Walker's question, when is it not going to be natural and predictable that breaching a very multi-million-dollar contract in the foreign country is not going to have a direct effect on the operations of the company in the United States?
Yeah, I think at least in a circumstance like this, in which it's a U.S. headquartered company with extensive United States expertise at a time when, as the district court found, there were all sorts of technological limitations in Iraq. So there was no real functioning internet, no real functioning banking system and the like. A lot of that is going to have to happen in the United States. This is well before cloud computing and things like that. And this required, as the entire volume 4 of the Joint Appendix shows, the construction of a very extensive database in order to try
It
and.
sounds like in any country that is either, whether for war or other reasons, is underdeveloped industrially, that you're going to have a contract with the United States company is going to mean direct effects in the United States.
Yeah, I think, again, the question is, would it be natural and predictable for a contract at this point in time in 2004 to be
No,
performed in the United
We don't get
States?
to decide, we don't get to write an opinion that says that this is good for 2004.
Well-
And so I understand talking about a wartime there, but there's contractors, military contractors, all kinds of contractors
I think-
all over this world, and they're US-based companies.
Right.
And there's no doubt that they are having communications with, no doubt that logistical issues are affecting the US, that probably even directed by folks in the US offices. And I'm just very worried about, I don't understand how I
Yeah.
can write the opinion. How would I
I
write
think-
the opinion that says,
I think
is it
you're
good
right.
for one ticket, ticket one
I
day
know,
only?
yeah, I'm not suggesting quite that. I am just saying on the facts of this case, all you'd have to do, I think, is say, look, Judge Lamberth found at this moment in time, there were technological limitations which made it absolutely foreseeable and a natural and predictable result that someone who's signing this contract with a U.S. headquartered company involving United States experience of its personnel, of its key personnel, that it's going to be performed in the United States at this moment in time. Some other contract could be done differently.
What
And
do you
of
mean
course,
involving United States experience of its personnel?
Well, I mean that these are, the Stoffels were United States people. They were, they had.
Well, that's my hypothetical. That's any question. That's US-based companies.
Yeah, and I think, if you have, if you have a contract with some other company that is not have the locus of its expertise in the United States, I think it becomes less the natural and predictable results. But on these facts, as
Okay.
this district
That
court
doesn't give me
found,
any reassurance about writing an opinion. That means every time a US-based company sends some people overbroad to help overseas to help execute a contract in a foreign country, that they're not always going to have.
well, I think that, again, I think it may be different now because of the role of technology and the fact that there's cloud computing. It'd be harder to anticipate performance in the United States. And then,
If the logisticals designs are put on computers and created in the United States, if the spreadsheets are all done in the United States, if how we're going to,
And-
we have great tech here, not great tech there, how are we going to bridge that is decided in the United States, they're all going to be.
quite understand. And Your Honor, if you're worried about that, I think the answer to that, as I was saying to Judge Walker, is that the contracts itself can specify whatever they want about performance. They could say it's not performed in the United States or whatever, but at least in a contract like this, in which I think all the indicia and hallmarks are that this is the natural and predictable result, that's enough. And of course, that's only about direct effects. We haven't talked about, the impact on the military or the bank account as two other reasons for direct effects. If I could.
Can I read a couple things from the reply brief? I suspect you agree with some of these statements and disagree with them. I just want to know, agree or disagree. Wyoke pitched the contract in Iraq,
Wyoke pitched the contract in Iraq? Yes.
signed the contract in Iraq,
Yes.
Governed it under Iraqi law.
Yes.
And I think you're
I
going to
mean-
disagree. I think you're going to disagree
Well,
with this.
Well, the contract itself says that, but then obviously, as our briefs explain in the district court, there were all sorts of concessions with respect to specific arguments that Iraqi law wasn't different than United States law.
was not different.
Right.
And then I think you disagree with this. Wyoke was to perform all work under the contract in Iraq.
Oh, yeah, absolutely disagree. And my
Okay.
friend on the other side said
That's
that.
part of the debate's about.
Yeah.
And then, this is not from their reply brief, but David Stoffel continued to perform up to the January 25 election. Is that right?
I think that's about right. I'm not sure about the exact date, but yes, there was continued performance for a couple of months.
And U.S. officials, Senator Santorum, et cetera, they took no action after the breach until Wyoke reached out to them. Is that correct?
I'm not quite sure about whether that's true or not. It was the case that Joint Appendix pages 584 and 429, the district court says that the reason why U.S. officials got diplomatically involved was because of the failure to pay.
But what actions did they take before Wyoke reached out to them?
I'm not sure they took actions necessarily before, but they certainly did once there was a failure to pay.
How long after the breach did Wyoke notify somebody in the US military about the breach?
I think it was done pretty quickly.
What's
Yes.
that mean?
I mean, probably a matter of weeks. I'm not sure exactly, but it was a fairly fast, rapid situation because this contract was so important to the United States for reasons Judge Ginsburg was saying, so important to Iraq right before the elections that everything was done to try and, make sure that that contract was preserved. And we're certainly not saying that alone is enough of a direct effect.
We talked earlier about what General Petraeus did and didn't say. Just in terms of your contention, is it your contention that if Iraq had not breached the agreement, U.S. forces from Iraq would have returned sooner?
Some U.S. forces would. No, we're not saying every troop would have come home, but that was the testimony at the trial. That's what Judge Lamberth found after hearing that after 8 days.
I think this is my last question, but as you know, Odiombo has some language very unhelpful to you. For example, breaching a contract that establishes a non-U.S. place of performance can affect the United States only indirectly as the result of some intervening event. Do you think we have to at least disagree with the language in Odiombo in order to decide for you?
I don't think so. So first of all, that is only going to get to the cutoff of funds thing. I think it won't get to the military impact that Judge Ginsburg was isolating or the bank account that Judge Millett was getting to. But with respect to the language from Odiombo, that case had no United States connection at all. It involved no performance by any party in the United States. It was just brought by someone who brought
That's an
unilaterally.
argument that Odiombo's holding doesn't control, and I know you think that, but the language that it gets repeated at least twice expressly in Odiambo. And then, as you know, I think it was Judge Pillard says,
Exactly.
you know, I don't agree with this language in Odiambo. I guess I'm asking, do you agree with it?
So I think it could be read more loosely, and I think you should read it that way. I think Judge Millett in the Hanson versus Trump case said you've got to read cases in light of this court's decisions in light of other decisions. And to read it for all it's worth, the way that I think my friend on the other side is, would run it headlong into EIG after all, which says it's the natural and predictable result. That is the relevant test. And so I would just, I agree, Odiambo is their best case on the cutoff of funds. I just don't think it could be read to be that way, because if it is, then EIG, I think, comes out the other way. McKesson, as I was explaining to you, would come out the other way because it was the US company's choice to keep its personnel there after the nationalization. And you know, I think it's also inconsistent with Volambia, as I was saying to Judge Ginsburg earlier, because that's a case that says it doesn't need to be in the contract expressly, it's contract or otherwise is the relevant language in Volambia. And the last thing I'd say about this is,
Very, very, very fast.
the last thing I say about this, my friend makes a big point about immediate in his briefs, but there's two different senses of the word immediate. One is causal and one is temporal. It's clearly, the use of that phrase in Weltover is clearly causal because the language at page 618 of the Supreme Court decision says, we agree with the Court of Appeals about the test. And the test from the Court of Appeals, and this is 941 F. 2nd 152, is that, quote, an effect is direct where there is no intervening element.
Thank
Here,
you.
for those three direct effects, there's no
Yep, thank
intervening
you.
element.
Thank you very much. All right, Mr. Morag, we'll give you 2 minutes for rebuttal.
Thank you. First, just some points on the case law that was raised. The Sheppel clearly is about the decision. What it found was that Hungary had promised to make specific performance obligations in the United States. That's what was alleged. That's what Judge Tatel relied on for his decision. This test that's being referred to about the natural and foreseeable was in fact rejected in Weltover because this is a question where foreseeability was rejected. Yes, it is causal, but it's a proximate cause analysis. It's not a but. You don't look at every but-for issue. And the point of that is that you look at what the sovereign was required to do, and you look at what happened next. All of these points about why Oaks, it has to matter whether Wye Oak could perform for 3 months or 3 years after the breach that it claims is the gravamen of this offense.
Follow up, you said, I thought I heard you say that Iraq agreed to pay in cash in Baghdad for this contract performance. Does the record say somewhere that it was in cash?
Yes, I believe so. That was the whole point, that
December?
that Mr. Stoffel left the Taji base to pick up the funds in the green zone in Baghdad.
Well, he says you arrange for the payment and get it. So that could equally mean he was going there to arrange a wire transfer to the US.
There were no wire transfers going on. There's testimony about that from Captain Neal, that wire transfers were not happening. That's why everyone understood that this payment would have to come in Iraq, as it in fact did come to Mr. Zaina for reasons having to do with.
Do you have a record citation for where it was going to be in cash? Or not off the top of your head?
The description in the 2019 decision by Judge Lambert discussing the events, and there's an email that was sent where before the date where Mr. Stoffel says, I'm going to get the money. Whether it's a cash or a check, it was still going to be some instrument in Baghdad.
Okay, thank you. Thank you very much. Mr. Cowtail, you wanted to reserve 1 minute for your cross appeal. I'm not sure it has come up at all in oral argument, but if there's something that you fairly want to say in rebuttal on that issue, feel free, but otherwise.
Just that we isolate 3 reasons on the cross appeal for why why the district court made some errors, and we think it should just be remanded for a discussion of those.
Okay,
If there are any
any
other questions.
Thank you very much. The case is submitted.
Honorable court is not practiced until Thursday, the 31st.